Good morning. This morning of June 7th, the year 2021, we're gathered this morning to start the 2021 Board of Review for the City of Fitchburg. As we start this, I'd like to first start by doing a call to order. So please recognize the fact that we are here and this meeting is being called to order. To make sure we have a quorum, would the clerk please call the roll?
Chair Couillard,
Here.
Elton Krim Jr., Craig Stevenson,
I'm here.
Rich Tate,
Here.
Matt Polda. Try for Elton again.
Please let the record show that Elton is joining us via Zoom, and right now his screen is blank.
We do have a quorum even without Elton attending. We do have 4 board members present.
Okay, very good. Since we have a quorum, we can proceed as required under statute. Next thing on our agenda is approval of the draft minutes from our last meeting of October 16th of 2020. They were included in the packet that was put out on the internet for us to review. Hopefully everybody had a chance to review them. Are there any changes, corrections, or additions that need to be added to the minutes?
I was just reviewing the minutes on Executive Offices LLC, 2923 Marketplace Drive. And it says that the motion carried unanimously, and I don't think that's accurate. I believe our chairman voted, so I had made a motion to adjust the value to 2376.9, and I think Mr. Couillard voted no on that, but the motion did carry by majority vote. That's my recollection, but if somebody thinks that's not what happened, I'll stand corrected, but that's my memory on that.
Your memory is correct.
Okay, so I just think it says motion carried unanimously. I think it should just say motion carried by a majority vote with Mr. Couillard dissenting or voting no. I didn't have anything else on the minutes.
Okay. Anything else? Hearing nothing, I would accept the motion to approve the minutes as amended.
Second?
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Please note that the motion is carried. And Eldon is back on Zoom, so hopefully he can hear us.
I can.
Excellent. One things I always like to do is to make sure that our meeting has been properly noticed. So I'll ask the clerk if the meeting has been properly noticed as required under Wisconsin Statute 7047.
The meeting has been properly noticed. It was noticed in the newspaper on
Is your microphone on?
Hope it's not. Yes, the meeting was properly noticed on 4/26 of 21 for open book and for Board of Review scheduled today.
Excellent. Thank you for your work on that. Also, Wisconsin law changed that we have to have at least one member attend the mandatory training annually. Has that requirement been met?
That requirement has been met. Chair Couillard attended the training this year.
Filing and summary of annual assessment report by the assessor's office. Is that ready for submission?
Yes, it is. You have a copy in front of you to your left between you and Matt. I have a second copy in front of me. Would you like a summary of what occurred this year?
First of all, I ask the question, has the assessment roll been signed and certified as complete?
It has.
So the affidavit has been signed.
The affidavit, yes, the affidavit was signed.
And when was that signed?
I got it right here. The assessor's affidavit was signed on June 4th, 2021 by the assessor and then witnessed by me, the clerk.
Excellent. Yes, please continue with the summary.
Okay, so I took my oath of office on January 14th of 2019. The personal property returns were mailed out December 27th of 2020 and due March 1st. We mailed out requesting for income and expense on December 28th of 2020, and those were also due March 1st. We mailed real estate and personal property notices on April 28th of 2021. Open book ran from May 14th, 2021 through May 20th of 2021. Renotices for anyone that attended open book, those determination letters went out on May 21st, 2021. All agricultural parcels were reviewed. All personal property were reviewed or dumaged. Mobile home park was also reviewed. All sales that occurred during 2020 were reviewed. All permits were reviewed. All fires were reviewed. And we also reviewed all the splits, merges, that aspect throughout the year. This assessment cycle is a maintenance assessment year, which is a little different than what you're used to. We typically do a revaluation each year, but because the 2020 revaluation was so extensive, we chose to do a maintenance assessment year this year. What that means is we still review all of the same data when we collect. We update all of our property record cards for sales and things, but we do not adjust for market, okay? So if you did not have anything that changed on your property, like you didn't add basement finish, your assessment would have remained the same, unless we found some type of data revision or classification change, something like that. I do have little packets if anyone would, if you'd like them. Do you want to hand those out? We inserted a flyer this year with anyone who had a change of assessment notice. So the top copy is that flyer that was included to kind of explain the difference between a maintenance year and a revaluation. We also sent out postcards to all property owners, letting them know the open book and board of review dates, and that it was a maintenance assessment year. Can you give me one of those? Just one. So the first one is just a little flyer we included. The second stapled copy is some frequently asked questions that assessors throughout the state asked of the Department of Revenue. Because of COVID, we asked for some clarifications. And those were questions that we requested and answers that the Department of Revenue guided assessors throughout the state how to handle things. And then the last page is our 2021 summary of reasons for change for the real estate parcels. So that basically tells you where the 2020 values were on the left and where the 2021 values are on the right. So if you look at that, you can see the majority of the change has to do with the new construction, new plats, new improvements, and that. Those that fall under the revaluation categories of the -5 and +5s for decrease or increase, those have to do with primarily data corrections that we would have had that would not fall under the new construction category.
Any questions on the information submitted by the assessor?
And this information we've also included on our website so that everyone can view it, like the maintenance or the assessment questions and that we've included on our website.
So what I'm seeing in the summary is that there is almost $60 million of new residential construction and $128 million plus in commercial construction.
Correct.
The city is changing.
Yes, it is. We're very busy for a maintenance year.
And based on this information, what was your indicated or estimated level of assessment?
Our estimated level of assessment overall is 95%. And I want to reinforce that's overall because Fitchburg is extremely diverse. So, you know, anything under kind of that median purchase price for residential of around $330,000, you know, if your home was in the value of a $200,000 range, it's probably over that 5 or 6% increase that we would have. You know, those might be at 15%. So that's what we see typically when we revalue. Or like those homes that are $1 million homes, those might have actually decreased this year and not increased because, you know, people might choose to buy a brand-new home and build their home instead of buying an existing executive-type mansion. So when we revalue, then we'll adjust again. But that overall level of assessment is coming in at 95%.
In looking at your summary, I see it does not include manufacturing, Code 3, recognizing that there's been a significant amount of that construction in the city in the last year, and understanding that that is handled exclusively by the Department of Revenue Manufacturing Assessment Section. Is that correct?
That is correct. There are a few properties that we are still locally assessing because they were not complete as of January 1. So anything there, for example, Promega on Sub-Zero Parkway, that is still locally assessed. We believe they will file for the state to take them for 2022 when that property is complete. So that's when we'll have class shifts and things like that occur.
Okay.
But the state does not take it if it's under construction. Only until it's complete will they take it, is what we've been told.
Excellent. Anything else to add?
No, I think that's it.
Okay, let's move on to the next item on our agenda then. The review of the assessment role and statutory duties. As we can see, the assessment role has grown to multiple binders. And to sit here and review and look for corrections and errors would be a very substantial obligation and would take more than the 2 hours we'd have scheduled for our first meeting. So I guess I'm going to rely on the assessor to conclude, and I'll raise this as a point and I'll ask you to confirm it, that the assessment role has been thoroughly examined by your staff and yourself before signing the affidavit, that you've worked with Dane County to make sure that all the changes of ownership and changes in descriptions have been accomplished, and to the best of your ability, you're presenting an assessment role that's complete and accurate for us.
Correct. In the back of the roll, we do have one correction of error under statute 70.43. It's one personal property account.
Okay?
And so that is in the back of the roll and has been addressed already. But no, we've continued to do our audit reports extensively to make any corrections. We've balanced with the county prior to sending notices, at the end of open book, and then I did have 2 waivers that came in, 2 changes that occurred after open book ended and prior to the board, and those were handled with a waiver, and I've put copies of the 2 waivers in the back of the roll, and the county has already made those changes also. So we should be completely balanced with the county at this point in time.
Excellent. And there were no double assessments or anything else to correct this year?
The only one is that personal property account 15-42620, that has been addressed.
Anyone else have questions of the assessor on the actions under this group? Hearing none, we'll move on. And I think we've covered 9 and 10 as we've looked at them. Discussion of the corrections and also verification that the open book changes have been included. Next thing on the agenda would be review notices of intent to file objections. And I understand this morning our schedule is set up that we're looking at strictly residential properties. Is that correct, Ms. Clerk?
That's correct. Some waivers. That's correct. We do have waivers and a little bit of other business to discuss. But the hearing is just for residential properties.
Okay,
We do have one personal property that is listed on there that they filed late, or not filed late, but they did not discuss with the assessor during open book process.
okay. So residential properties and one personal property are on the agenda for this morning. One thing I probably should have asked everybody to do before we started, and that is to please silence your cell phones. You know, sometimes I forget to do that, and it's sort of annoying when, especially when you're on a record and have your cell phone ringing. So if you haven't done that, would you please take a second and silence your cell phones as we're in session, that we don't get the unwanted interruption that happens sometimes when your cell phone rings when you least expect it. So you said we have some waivers to consider? Let's consider them. And these are in our packet of materials as well?
They are. So Hy-Vee Incorporated at 2920 Fitchburg Road, parcel number 0609-072-0015-2 is requesting a waiver to Circuit Court. And I have the waiver form here if you wanted to review it.
For the record, this is a continuation of the appeal that they have been working on now for several years.
Correct. This will be the third assessment year that will be added on. And we've spoken with them concerning that. We're not in contention of it because we have the circuit court, as long as they don't add any more appraisals or things like that, because that's what keeps extending it out.
And has Mr. Ebbett filed the proper authorization to represent Hy-Vee?
Mr. Chairman and members of the board, this is Amy Seibel speaking. I'm representing the city in the circuit court matter, and I did have a discussion with Attorney Ebbett beforehand and told him that we had, on behalf of the city, we had no objection to entering into the waiver, seeing that we're already in circuit court and we have a number of years of appraisals already in place in the circuit court proceeding.
And the assessor's office agrees with that?
Yes.
That being the case, then, any discussion on this waiver to let it go directly to circuit court?
And this is a copy of the agent authorization form showing that they are appointing Jack Ebbett.
Okay, so we have the waiver request and authorization as agent. I would ascertain a motion then to approve this request, to waive it to circuit court.
So moved.
Second.
So moved and second. Any discussion? Hearing none, motion is passed. I will approve and sign this decision so that it can be continued as part of the appeal in circuit court.
Excuse me, Mr. Chairman, should we call for a vote signifying aye in favor of the motion?
Certainly can. All those in favor signify by saying aye.
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 Hearing no objections, the motion passed. Review notices of intent to file. Do we have any notices of intent that we need to take care of or consider?
Nothing new has come in other than what is already on the agenda,
Okay,
to my knowledge.
so that moves us then to item 13 on our agenda. Hear, deliberate, and determine the following objections.
Mr. Chairman?
Yes,
Again, Amy Seibel speaking. I'm wondering if we could just take a few minutes. I have a conflict this morning, and so we have a number of subpoenas that I would ask the board to address, if the board is so willing, before you hear the residential cases, because I will not be representing the assessor on the residential cases. So I would ask that we just take care of some subpoenas and some procedural things on the commercial properties before we get into the valuation of the residential properties.
okay. So you're asking us to adjust the agenda to move from item 13 to item 14, section D, consideration of subpoenas.
Yes.
Any objections to adjusting the agenda from that to that by the board? Any objections, please signify by saying object. Hearing none, let's listen to that so that the attorney can then get us the information necessary so that we can work with the assessor's office to gather the necessary information to make any corrections or additions or changes that are necessary to the assessment. So we're now moving to item D, item 14 on our agenda, consideration of issuance of subpoenas as requested by the assessor. So please continue with that.
Thank you. There are a number of objections that were filed this year pertaining to properties where there were objections last year. We are not in circuit court on any of these matters. Some of the subpoenas pertain to properties where subpoenas were issued last year, and there was a motion to quash the subpoena, and the board heard the motion to quash and dismissed the objections because the taxpayer did not provide the requested information in the subpoena. So now we're back at another year, and we would like to, not having received any information from the prior year, we would like to receive the information this year by virtue of subpoenas. So there are some subpoenas, and I'll ask the assessor to go through what the property numbers are and the property tax parcel numbers. But some of them pertain to objections from last year, and then there's a couple of new ones this year where we have taken the opportunity in preparation for today's hearing to prepare the subpoenas for these properties. So we have them readily available. And would ask that the board entertain a motion to sign the subpoenas today. And we will issue them and serve them on the various different taxpayers or their representatives. And we have a return date for the information to be received. And I believe, is that June 24th, Amy?
Correct.
Okay. And so with the June 24th return date, that's when the information has to be provided to the clerk, who then in turn gives it to the assessor. And then we would ask for a hearing date sometime in July. You don't have to decide that right now, but then a hearing date sometime in July where we would all reconvene again, and we would report back to the board whether or not there has been compliance with the subpoena, and then the next steps that would be required. But for now, we would ask the board for the properties that I'll have the assessor read into the record one at a time, and actually then to provide the subpoenas. And the issuance of a subpoena, just to recall, it is authorized under Wisconsin statute 70.47 sub 8 sub D, where the statute states that if the board or if the assessor requests the board to issue a subpoena to gather additional information, the board shall sign the subpoena. And so we are acting under the statutory authority granted to the assessor by virtue of the board's power, subpoena power. The assessor does not have subpoena power. So the assessor can ask for information, but it's purely voluntary. And if the taxpayer doesn't provide the information when it's requested, the only way to get the information is by virtue of the subpoena power of the board. And so as a result, we would ask the board to sign the subpoenas, the board chair, to sign the subpoenas so that we can get valuable information to analyze the assessment to determine if it is fair and equitable, and then come back to the board with that analysis.
Please continue.
Okay, so under item 14D, the Fahey Fields Apartments LLC, there are 4 parcels, 0609-151-5468-2, and that's 5359 Noble Drive. There's 2600 Smoky Trail, parcel number 0609-151-51012, 2591 Bob's Drive, 0609-151-52692, 2603 Bob's Drive, 0609-151-52592. This is an apartment building that is new this year, or it was completed as of 2020, and we do not have any income and expense on that parcel. D2 is Bowman Farms, Inc. and Bowman Plaza, Suite 222. That address is 2934 Fish Hatchery Road, parcel 0609-031-88152. AMC Theater, 6901 McKee Road, parcels, there are 5 parcels here. The building overlaps 0609-071-1005-8 and 0609-071-0910-4, so those parcels are assessed together. 0609-071-0075-6, 0609-071-0150-4, and 0609-071-0225-4. Those are 3 parking lots that are utilized for the overflow of the movie theater. Then there's Artisan Village, which is 2845 Oregon Road, parcel number 0609-012-8605-2. Those are listed under item D, and I don't know if we need to discuss this at this point in time also, but item 14C was listed as consideration of future procedural hearing for possible dismissal or of objection for failure to provide income and expense to assessor as requested. And Amy can expand on this, but parcels, items C1 through 5, again, are items that we requested income and expense this year, but did not receive that for these parcels. And we've prepared subpoenas for these also under item C for all of these. These 5, because we do not have the income and expense, and we would really like to obtain that information so we can verify that our value is correct. So those parcels would be the Fred Fitchburg Retail, 2945 Fish Hatchery Road, parcel 0609-031-55679. Fred Elon, owner 6311 Quarry Vista Drive, parcel 0609-182-2505-2. Franklin Square Condominiums, and that is 2001 Greenway Cross, parcel 0609-031-2273-0, and 2004 Greenway Cross, parcel 0609-031-20867. There's Hatchery Hill 3, which is 5550 Cadiz Bend, parcel 0609-033-41913, and 2981 Cahill, Maine, 0609-033-422 6-1. And then Fahey Fields Apartments LLC, 5345 Noble Drive, 0609-151-5362-2. And there are two others under this category that we're requesting for subpoena. Both of these, we did request I&E information, but they are primarily owner-occupied with just a small tenant, so, or no tenant. But we did request it. It was not received. But both of those, we would like additional information to verify the value. Item 14C6 is Park Bank. On here, it says ATM 6529, but I actually checked with the county because there are two parcels there that are assessed together. And those two parcels, I verified the ownership, and it's actually, the ownership's name is the Park Bank, and they are assessed together as one economic unit. On here, it only lists one parcel number, but let me just verify what that second parcel is. So it's parcel 0609-031-21580 and 0609-031-21697. So those two, the building is actually an economic unit. It overlaps both parcels. And then the item 14C7, all soccer inline hockey, is 5964 Executive Drive, and that's parcel 0609-082-00388. So all of those are the ones that we are requesting subpoenas, and that I have the subpoenas ready for the board. Depending on each property, there are different items that we would be requesting.
Any questions on the request for subpoenas?
I just have a quick question. So we haven't seen the subpoenas, but can you just confirm that the information requested in the subpoenas is appraisals, documents, or other data which may throw light on the value of the properties for which the subpoenas are sought?
Correct. So like a couple of these are new construction. One Glen Place was built and completed for 2020. We requested information last year through a subpoena, and they did not provide that information. So we do not have the construction costs. We do not have a private appraisal on it. We do not have income and expense on that because they didn't. So all of these are depending on the building itself. We have different items. And, you know, I know Amy is here now. If the board would like to, you know, either make the decision now or come back after we hear the residential, review the subpoenas, and determine what you would like to do. You know, that is, of course, your decision, not mine. I'm just requesting additional information so I can verify that the values are correct and appropriate, especially being it's a maintenance year, and it's really a carryover from the prior year, a lot of these.
So you're seeking income and expense information basically from income-producing properties.
Correct.
Bowman Farms and Bowman Farm Plaza. I'm not sure what Bowman Farms, you know, the title
So
sounds like it's a farm, not a commercial property.
No, 2934 Fish Hatchery Road. That is on Fish Hatchery Road. That's the former gas station and Stop and Go. And so in that, they had the gas station, and actually the gas station itself, that, I guess, lease, was purchased by Quick Trip, so they've closed that gas station and that front portion of the convenience store. But it has Pizza Extreme in there, it has the laundromat, it has Pancake Cafe. I think it's a insurance agent is in there also, is what's coming to my mind. But it is an income-producing property. Part of it is occupied by Bowman Farms, you know, to do their business out of. So it's retail, office, convenience store, restaurants.
Okay.
We
I
did,
I can confirm that we customize each subpoena to particularize it to the attributes of the subject property. We don't have a standard subpoena form where we just fill in the name and the address. We look at the property and we request information only that will be helpful in, will tend to throw light on the value of the property, which is the standard under the Wisconsin statutes. So we try to be, we don't want to waste anybody's time, not the assessors, not the taxpayers' time. So we try to be very, very specific in what we're asking for.
Any additional questions from the board? So in total, if my calculation is correct, we're looking for 21 subpoenas, or there's a 20 with the Park Bank being combined into one?
there's actually 11 subpoenas total. Because a lot of them, it's the information is for that total property owner, is how we've organized the subpoenas. Because a lot of them, like the apartment buildings, if they own one Glen Place, they often do not break it out between all of the properties. And they view it oftentimes as one item when they provide us the information. So each one is broken out per owner, and then the parcels under that owner. We do have the 2 for one Glen Place, like we requested last year. One is of the owner, and one is of the bank, Associated Bank, who owns that mortgage, requesting the appraisal from that bank or their documents.
Okay. Pleasure of the board. Should we move on this now?
I'm satisfied that the information requested is within our power to subpoena under the statute referenced, and relying on the representations of the assessor and the council present today, I think we should authorize the subpoena so the assessor has the information. I did note that the agenda item says consideration of future procedural hearing for possible dismissal of objections for failure to provide income and expense. I take it from the presentation today that we're not being asked to act on a dismissal, but we're being asked to authorize subpoenas to get information. If information is forthcoming, we'll be asked to hear a further presentation on that. But if the information is not forthcoming, then at another hearing, we're going to be hearing that the information requested in the subpoena was not provided, and then we're going to be asked to listen to something about dismissal. But that's not what you're asking us to take up today. It's to give them another shot to give the information pursuant to the subpoena. Is that right?
You are,
Okay.
yeah, both of us are saying yes.
Okay. So, yeah, with that understanding, I think I would make a motion for the board to approve the requested subpoenas for the 11 parties that are listed under agenda items C and D of paragraph 14, so that the assessor can receive that information.
We have a motion. Do I have a second?
Second?
We have a motion and a second. All those in favor signify by saying aye.
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 Please let the record note the unanimous decision. We will sign the subpoenas so that they can be dispersed to the property owners as soon as possible, so you can hopefully get the information you need to prepare an accurate assessment for those properties.
Thank you.
It appears as if that takes us back.
Amy, did you want to talk about the procedural matter with Bowman Farms or with Fred Fitchburg? Don't we have some procedural matter with incomplete objection forms also?
There's quite a few objection forms that, these pertain to, primarily all these subpoenas, that the objection forms
Well, no,
Although-
not the ones that we've issued subpoenas on. I thought we talked this morning, maybe I'm wrong. And so I don't want to take up anyone's time if I've got it wrong, but I thought that there were some incomplete objection forms for which we have not prepared subpoenas, that we wanted to ask the board to order the completion of the objection forms so that we can then decide how to move forward. Some of the lots, aren't some of the Bowman Farm lots?
Correct. There are actually 4 parcels that currently that they have filed for circuit court that we waived last year, but the forms, I believe, are not filled out, I guess would be accurately, correctly. A lot of the forms that had been turned in by Attorney Millis, they might have the box checked no for new construction, but they had new construction on. They are 2 of the vacant lots in the 4 that are Bowman Farms that are in circuit court action. 2 are vacant lots, and I believe that they have them for sale, but they don't have any information saying that they're listed for sale, but I can find them on LoopNet that they are for sale, and there's signs on them saying for sale. And so there's no asking prices filled in. So we're asking that there are certain properties on the list for future that I would actually ask the board to either request of the owner to appear or their agent to appear and fill out the forms completely. You know, they consider it complete, I believe, by checking a box, even though it's not what I believe is the correct answer, based on my, our discovery.
So the record is clear, you're asking the board to present or demand that the taxpayer's representative, if that's the case, change the assessment objection form to represent actual activity on the property versus just checking a box and saying the form is fully completed.
Correct.
I noted that when I reviewed the parcels and the information that was submitted to us in advance over the weekend. And I did discuss that with the clerk of the Board of Review this morning. And I have requested an opportunity to discuss this with the city attorney. So we're not going to take this as an action this morning because I want our attorney to review the situation and give us the opinion of the city as to whether or not the objection forms meet the criteria of being fully completed. And hopefully that's going to happen this afternoon. If it does, I will then ask the clerk to notify the taxpayers that their objection forms are not accurately completed and we will not accept them and they will not be offered a hearing. Since the commercial hearings are not today and these are all commercial related properties, I think that's the best way that we will proceed with them at this point so that we can make sure that we have, and you have, a complete objection form to know how they've established their opinion of value so that we can then proceed and make sure that you have and we have correct information as we schedule a hearing or not.
Thank you. I do have copies here that I just have my copy, but I can have one of my staff make a copy or make 4 copies for the board if you'd like to see those after we hear the residential and you want to look at where we've made notes as to, oh, this had a permit or this is for sale, things like that. So if the board would like that, we can make copies and provide that to you.
The objection forms themselves were in our packet. And that's where I noticed the potential concerns. And so if the members of the board would like to review them, they are all in the online information. I'm not sure if we have the commercial objection forms in our packet this morning. Possibly we do. It's over an inch thick. I haven't reviewed it all, but they are online. So I don't think we need a second copy, but we do need an attorney's opinion as to whether or not the forms have been fulfilled as required by law.
Okay, thank you.
Anything else on that? Any discussion by the board? Well, with that behind us, it appears as if we are ready to hear and deliberate our first cases of the day. And before we do that, I'd ask the board if anybody needs a 5-minute stretch break to make sure that we're all comfortable as we start the hearing so that we can continue and not have any interruptions. Anybody need a break? Offered and turned down, so let's continue.
I'm going to sign off now, members of the board. Thank you for your kind attention.
Thank you.
Well, first I'll ask, of the clerk, is our first objection representative here?
So our first hearing is for Dennis and Nancy Lynch, 2603 Placid Street, parcel number 0609-161-4716-2. And I believe Dennis Lynch is in the audience. Dennis, if you want to come on up to the table there.
Good morning, Mr. Lynch.
Good morning.
Welcome to the Board of Review. As we start this procedure, we have a few things that we need of you. And the first, we're going to do it both you and the assessor staff, is the law requires a sworn oral testimony. And so we're going to ask you to take the oath along with the members of the assessor staff that will be presenting testimony this morning. So I'd ask the clerk to please swear in all those who will be testifying.
So I'll be swearing in the assessor's department, and I'll be swearing in the property owner, which is a residential property. Your land assessment was $71,400. Your improvements were $326,200 for a total of $397,600. And if I could have you all raise your right hand and repeat after me. Or actually, you don't repeat after me, but I'll ask the question. Do you solemnly, sincerely, and truly declare and affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? And this you do under the pains and penalties of perjury.
I do.
I do. Amy Mercer, City Assessor.
I do. Nick Hare, residential appraiser.
And if I could get you as
Dennis
a,
Lynch,
and your address?
2603 Placid Street.
Okay, thank you.
You can say your name.
Did we get everybody?
Couple more.
I do. Bart Taylor, City Assessor's Office.
I do. Dwight Price, residential appraiser.
I do as a appraisal intern.
Thank you. Just to give you a little background, Mr. Lynch, as to how this works. Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving that the assessor erred in determining the total value of your property under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. Those standards are: the best evidence of value is a recent arm's length sale of the subject property. Next would be sales of reasonably comparable property. And lastly, all other approaches to value, which would include the income approach on income-producing properties, the cost approach on special purpose properties, and unique properties if there's not an active market. Please note this does not include a comparison of your neighbor's property unless it recently sold in an arm's length transaction. At this time, please share any exhibits that you would like to have read into the record. If you have an appraisal of the property under review, the appraiser must be here today to present sworn oral testimony for the Board of Review to consider. And to try and keep this on time, I'll try to give you a 2-minute warning. We try to set a reasonable time so that we don't get too far off schedule. And If we get too far off schedule, I'll give you a 2-minute warning if that's okay, so let you know that we need to wrap it up as quick as possible. We're going to ask you to present testimony first, and then we'll hear from the assessor's office staff. Do you have any exhibits to present this morning?
I do. I submitted the exhibits. It was a cover letter with 5 attachments. The cover letter was sent to Tracy. I want to thank her and for her work that she's done. It's been very helpful in getting this packet together. I've completed the objection to the real property assessment. I've submitted the appraisal for the purchase at the time. I submitted the excess gain information to substantiate where we're at. I also have submitted recently a list of recently sold comparables, which you just referenced. And then I also submitted the sale documentation from the property information on the revenue.gov. I'm sorry.
We need you to present it to the board for consideration?
Yes.
So are you going to read your letter to us? So
Yes.
we know exactly what your concern is?
Yes.
Okay,
Okay. I wasn't sure whether I was starting or
You
where
are.
we were. Okay.
please continue.
I'd like to thank you for your time today. I appreciate the opportunity to come forward, and I know from talking with Nick, 7,000 plus pieces of property, and you've got one here trying to make some case. And I realize that the city has a certain methodology that it uses. And so I'm going to go through where I believe and where I'm asking for common sense. I worked for Marshall Erdman and Associates for a number of years, and the one thing that Marshall always argued was we ought to have common sense. And where I think the error is here is in the process and what was applied to me. There was no error in the way Nick did it. He was very clear about the catch-up year and how the appraisal was done. So I'm not here to find fault with that. But let me start by saying that my wife and I are the owners of 2603 Placid Street. We purchased the property known as Lot 76 in Oak Meadow on November 6, 2019 for $375,000. The sale was arm's length market sale, duly recorded by warranty deed on November 11th with the state of Wisconsin. After the purchase of the property, the city of Fitchburg sent an appraiser to our house to inspect the property and determine the assessed value for 2020. The assessment was set at $387,800, which was $12,800 over our purchase price, which I had a conversation with Nick at that time, which I thought was unfair, but I agreed to $387,800. At that time, we also, and I'm going to jump a little bit here, we talked about improvements that we were going to do, and the deck that was currently there, we were going to take the deck that we had and put a new deck on. Then in April, we received yet another increase in the property value because we replaced the deck and a screened porch. We disclosed this when the property was assessed and again discussed this when the fair market value was agreed upon last year. Needless to say, I was surprised and shocked to find that in a matter of a year, our property had been reassessed twice, once to establish the assessed value, the other to increase our property value for the replacement of a deck. In my opinion, and I ask this from you, I don't think you can do both. I don't think you can take an assessed value, which is pushing you to market value, which at that time was over what I purchased it for, and then secondly, in a totally different year, say, oh no, we're going to increase the assessed value because you put a deck on. Independent of what the value was that we established, that we said was over the market value at that time, we're going to do this because that's the rule that we have to apply it, and this is the catch-up year. And using metadata, and I understand the metadata process and how you're doing it for the entire city of Fitchburg, and you can't look at 2603 Placid, but I can, and so that's why I'm here. So I think the city assessed the value at $387,800, which was, again, $12,800 over the purchase price, and then has increased the property again $10,000 for the replacement of the deck, and now we are way over what I think the fair market value was. I can accept the increase if we had lived in the house for 5 years and we hadn't had an increase in our assessed valuation, but we put a deck on, that would make sense to me. I discussed this with the city appraiser, and unfortunately, I had no luck in making my point. I was quoted the city policy. I understood the city policy at the end, and I thanked him for that information. I just don't agree with the way one happened right after the other. And I don't think in the process of doing this, that was taken in consideration when you put the policy in place. So this makes no sense to me, and I'm asking for your help. Finally, we have owned property in Fitchburg since 1980, and each time our assessed value has been our purchase price. This is the first time that we bought a piece of property and our assessed value was higher than the purchase price. Most cases, we're taking an increase because we purchased the property and it was under what the purchase price, the assessed valuation, so it made sense to me. But to go the opposite direction and say, I bought it for less than what the city assessed it for, but we're going to take you back there just because we think that's what the metadata tells us, I don't think is correct. So I've included the objection. I'm going to go through the attachments that I have for you that I submitted. The objections to the real property assessment I completed, and I show the current assessment by the city, $397,600. My opinion, it should be $375. I don't think I'm going to win that one, but you asked my opinion. I signed it. My wife has participated in this, and she is fully aware. The second exhibit is the appraisal. The appraisal came out for the purposes of the sale of the property and the loan that we were able to purchase the property with, $385,000. The excess Dane information is correct, and it does follow what the city's assessment was, and that's our Exhibit 3. Our Exhibit 4 is 21 properties recently sold, City of Fitchburg, of 3-bedroom, 2-bath, and we're 2,600 square feet, so in that range of 1,900 to 2,700 square feet. And then finally, I included in Exhibit 5 the property information from the revenue.wisconsin.gov showing the $375,000 purchase price. So what I'm really here today to say is looking for fairness, looking for an opportunity to consider this parcel and the fact that from the purchase price to 2 years later, I'm now sitting at an assessed valuation of $397,000, where we purchased a price for $375,000. I think that's a little excessive, and I'd ask for some relief.
I have a couple questions. Typically, I'd just go to the assessor, but in this circumstance, there was a deck, but you say you replaced it with a deck and a screen porch.
It had a deck and a screen porch.
So both were taken down and replaced with a similar size replacement?
Yes. Well, the deck is similar size. The screen porch, we extended 2 feet.
And what was the actual cost of that?
It was probably, we had the same contractor do some other work inside that was cosmetic. Probably 15,000 in that range. There's no electrical. It was a wood deck with a screen porch.
And did they also tear down the existing?
Yes.
So that was included in the $15,000?
Yeah. It takes an hour to take a deck down, so it wasn't a huge cost.
Okay. Well, then defer to the assessor if nothing else.
Do I have an opportunity to respond?
Absolutely.
Okay, sure.
Thank you. Kai is currently distributing written information summarizing the basis for completing the 2021 assessment of the subject property.
Thank you.
And I will briefly summarize the written documents with oral testimony once she gets them all handed out.
Thank you.
So on the first page, section 1 is a summary of my qualifications to complete the assessment. My name is Nick Hare. I'm employed with the City of Fitchburg office as a residential appraiser. I have an Assessor 2 certification, which expires February 28th of 2026. I've worked in real estate for over 15 years and in the assessment industry for over 5 years. There are additional bullet points that expand on my qualifications. Section 2 states the purpose of assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as the market value of the property as of January 1st, 2021. Part A outlines the standards for establishing value. State Statute 7032 outlines that property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained, therefore, at a private sale. One such sales conform to the definition of recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used in determining a market value. Part C is information from the Wisconsin Property Assessment Manual that specifies mass appraisal as the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as the systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a maintenance assessment role, the estimated level of assessment is approximately 95%. On the next page, you will find a location map illustrating the subject property's location. And the next few pages are the property record card that contains specific data on quantitative and qualitative physical characteristics of the land and improvements of the subject. To note some more significant data, if you look at page 1, it shows that the property is a residential house. It is located in the Oak Meadow neighborhood. I did also want to point out that the 2019 assessed value was $404,600. So when the property was purchased in 2019, the 2020 assessment actually did decrease to $387,800. So the second page of the property record card shows building permit history, which shows a permit was pulled in April 2020 for the existing deck and screen porch. And then there is also a permit for solar in 2020, although we do not add any changes for assessed value for solar. There is also sales history, which shows the home was purchased November 16th of 19, but we have that listed as not a market sale because there was only 3% commission paid on the purchase price of $375,000. So considering there was, typical commission is 6% and only 3% was paid, we would consider the fair market value of that property at the time of sale to be $386,600. Given that, and only 3% commission was paid, given the homeowner is a realtor, and he was the agent for the purpose. He wasn't the listing agent, but since he is a realtor, only 3% commission was paid to the listing agent. The third page shows the notes section, and in this note section, it shows there was a 2021 open book appointment with the property owner via the phone. There was a drive-by inspection in December of 2020 to verify the completion of the improvements done with the permits, and the property was last fully inspected in December of 2019. The fourth page shows the land information for the property. And on the fifth page of the record card, I'll highlight a few items from there. The structure is a ranch-style residence, 1 story in height. It contains a total of 2,920 square feet of living space, which includes the basement finish. It was built in 2006. It is a construction and quality grade of B-, and its overall condition, desirability, and utility is rated at average. And there's other detailed information on the physical attributes contained in this record card. And then the sixth page of the property record card shows a sketch of the property, which was updated with the new dimensions of the screen frame porch and the updated deck. The next few pages of the document are the market valuation detail. The market valuation detail summarizes the assessment calculation as completed by our automatic valuation model. The model is based on Volume 2 of the Wisconsin Property Assessment Manual, and since this is a maintenance year, it's based off the 2019 arm's length sales. The next page in the document is a map that locates the subject and recently reasonable comparable arm's length sales. There are actually 2 different pages of comps. We typically only use 3 different comparables, but we also reviewed the appraisal that the homeowner submitted, and we actually expanded to 6 comparable sales by using the sales comparables that were also listed in the appraisal that he provided. So the first page shows comps 1 through 3 and the location to the subject, and the next page shows comps 4 to 6, which are the comps that were used in the appraisal submitted by the homeowner. So the report lists comparable sales that we determined and the best information that we have that represent fair arm's length, recent arm's length sales. The addresses of the sale properties are 5625 Old Oak Drive, 5628 Old Oak Drive, 2639 Castle Rock Drive, 2794 Hollyhock Street, 5213 Nine Bark Drive, and 5574 Longford Terrace. The sale date and prices are, for the first one, April 20th, or April of 2020 for $435,000. Comp 2 sold in May of 2019 for $426,000. Comp 3 sold in June of 2020 for $380,000. Comp 4 sold in May of 2019 for $380,000. Comp 5 sold in June of 2019 for $371,500, and Comp 6 sold in April of 2019 for $374,900. The styles of the comparable properties are all 1-story ranches. The subject and sales gross living areas, including the basement finish, range between 2,272 square feet and 3,292 square feet. The effective year built ranges from 2000 to 2006, and other data is listed demonstrating that the sale properties are reasonably comparable to the subject property. The report adjusts the sales prices for differences such as the lot, building attributes, age and condition, market location, and detached structures, if any. The adjusted sale prices of these comparables, after adjusting for the differences between the subject property and the sales, are $450,600, $444,600, $403,200, $444,200, $432,400, and $445,500 respectively. The adjusted sale prices of reasonably comparable properties indicate that the current 2021 assessed value of $397,600 is a fair estimate of the market value of the subject property as of January 1st, 2021. In summary, there is not a recent arm's length sale of the subject property, given that since there was only 3% commission paid, we do not feel that was a arm's length market sale. Consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using a valuation model based on Volume 2 of the manual and 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably compared properties, adjusting for the differences between them and the subject property. Thank you, and that concludes my presentation.
Okay. Any questions of the assessor's staff after the information was provided from the board?
Yeah, I have a question. Can you explain a little bit more about why the commission percentage charged on the sale, how that impacts the determination that this was not, determination by the assessor that this was not an arm's length? I think you said it wasn't an arm's length transaction. I know that doesn't sound right, but just explain that a little bit more, please.
Before you do, I'll give you a second to think about it. I need to take a procedural step here. I'd ask the clerk to please mark the information presented by the assessor as Assessor's Exhibit 1, and noting that the Assessor's Exhibit is a multi-page exhibit, that each page then be outset in an alphabetical sequence to reflect all the pages that were submitted. I'd also like to do the same thing with the exhibit that was read into the record by Mr. Lynch, which was his record. I'd like this to be identified as Taxpayers Exhibit 1, so that we also have that as part of the information that was in front of the members of the board. Also noting that Mr. Lynch did submit a copy of the appraisal that was done on his home. This has been accepted for information only because the appraiser was not here, so we could ask questions of the appraiser. We will not consider this part of the exhibit, but strictly basis that we have for information as to how you reached your conclusions.
Okay.
Thank you. I should have done that earlier. I screwed up on that, so thank you for the interruption. We'll now go back to the assessor to explain why he felt that the 3% variation in the transaction did not represent a market sale.
Hand notes? Okay. So when it came to the sale, we looked further into that sale, and Nick, actually, you contacted the power of attorney. So the seller was not the actual person who lived in the home. It was a power of attorney for that person. And they couldn't answer a lot of the questions as to, like, you know, how did you arrive at this sale price? You know, they didn't know a whole lot of details about that property. And then, did you contact the realtor also then?
Yeah, the listing agent.
So why don't you explain who you all talked to?
So I had spoke with the listing agent as well. and Louisa Enns, and she was the listing agent on the property. I spoke with her on the phone. I also have email correspondence with her, just asking regarding the commission paid, and she did confirm that on the purchase price of $375,000, there was only a 3% commission paid. I do have the email correspondence if you would like a copy of that.
I understand the facts. I mean, assuming for the moment that we'll accept the testimony by the assessor for what was related to the assessor by a realtor who's not present today to testify. But what impact do those facts have on the market value?
So when a typical buyer buys a property, and if you purchase, let's say with a realtor, like if I were to sell my property, I would contract with a realtor, and typically the buyer, there tends to be a 6% commission. In this case, there was a 3% allowance, I believe. And Nick will have to explain more, but there was a 3% allowance listed. And so that would have actually, if a normal person, someone who did not purchase it as a realtor, they would have paid an additional 3% on top of that as part of their purchase price. So our research showed that that purchase price was adjusted downward 3% based on that 3% commission.
When you say the purchase price was adjusted downward, adjusted by whom, and how did you learn that the reason for the adjustment was the difference between a standard real estate commission of 6% and what you're saying is a 3% commission paid on this sale?
So on the MLS listing, and I'm trying to catch up here, so I apologize. On the MLS listing, they had it listed for sale at $399,900. The listing agent was Louisa Enns. And so we noticed that it says the list date was 9/9 of 2019. And then the sub-agent commission is a 3%. Buyer agent commission, 3%. Days on market, 6. CDOM is 6 days. There were no competing offers. So it has on here the listing agent as Louisa Enns, but it has a sales agent as Dennis Lynch. So he was actually the sale agent along with the purchaser. So where typically either the sale agent would receive the 6% or it would be split with the sale agent as 3 and 3, well, he's getting 3% as a sale agent, plus he's paying the $375. So he's getting a 3% kickback after he purchased this property at $375, where a normal person wouldn't get 3% back because I'm not purchasing that property. So other sales that we have would be 3% higher because that buyer isn't getting that 3%. I don't know if I'm explaining it.
I think I understand. I'll wait and ask questions of the property owner when we go back to him.
So I understand this correctly, the sale price technically was $399,900.
That was the asking price?
Well, if you work it out, the sale price is $399,900, which is the asking price, with typical sale price then having a 6% sales commission paid by the seller. If that were the case, it would take the $399,000, that would be $12,000. You would take the $399,900 to $387,000, and adding the 3%, which would be the seller's commission, or you got the brokers and the listing and the two agents, the selling agent and the listing agent, the 3% there would take it to $375,000. And that's what he paid plus getting his 3% representing his ability to do that as a participating broker. Is that correct?
So it's, per the email correspondence, it was at the sale price of $375,000, 3% of that was paid to the listing agent. So there was, I believe, per Wisconsin law, if you're an agent and you're purchasing a property, you're not allowed to take your own commission. So what we then did is basically that $375 purchase price would be 97% of what the fair market value would be. So you divide that by 0.97. So if a full 6% was paid, the listing or the purchase price would be, what was it, 387.8, I believe.
Okay.
If, another question, so if somebody does it for sale by owner, is it standard practice to gross that up by a 6% to reach the fair market value if the buyer doesn't have an agent? In other words, if no commission is paid on the sale, is the assessor grossing up those sales 6% to reach the market value? The way you've grossed up this sale by 3% because there was a realtor on one side of the transaction but not the other?
Honestly, I can't say off the top of my head because I look at each sale individually when we would do that. So we would adjust sales, just like in a commercial property. If it said there was personal property involved, we would adjust that sale based on that. So I'd have to go back and look at every sale to see which one is, has been adjusted or has not been adjusted. So when we do that, we actually will then send in data back to the Department of Revenue saying where that sale price might be adjusted or might not be adjusted to list that. But all of that would be like on an individual basis. We would discover that when we review that sale and discover whether we have to make that adjustment or not. So we had two kind of things here that, you know, is this really out on the open market because you have an agent to another agent? And then you also have the question of the seller was a POA, and so it wasn't the person who actually lived there. Did they actually know and were knowledgeable about selling that property? So you could determine it as arm's length in one way, I guess you'd think of it. But then I believe you would have to adjust that sale price 3% upward to include that 3% commission that we typically do not have something like that. Or you would not consider it arm's length because of a knowledgeable seller about that property. So, and compulsion. I'm not sure what Nick coded that in the system. He doesn't know, so.
It's an interesting dilemma. We need to keep moving. Mr. Lynch, you had questions you might like to ask of the assessor staff?
Could I just make a summary statement? Is that possible on what I just heard?
Go ahead.
I think you're going down a slippery slope here. Making the assumption that every real estate transaction that happens in the market is getting a 6% commission is not true. There are organizations besides the for sale by owner, Redfin, MBM, a number of real estate entities are coming into this market and doing it for 1%. So to take a flat 6 and say we're going to apply that overall actually is going to get you in trouble this year and following. So that's point number one. Point number two, and Nick and I went through this at the time, was the house that we purchased, and I don't want to get into a lot of detail about the lady who we purchased it from, but had Alzheimer's, early onset Alzheimer's. The house had been ignored for 10 plus years. There were substantial things wrong with the house that we needed to remedy, and we were willing to do it. And So Nick, in what he discovered was absolutely true. He applied it and said, no, this is what you got. And I said, no. I said, that 3%, I would actually have taken it off the purchase price because of all the work that needed to be done and the things that were ignored for a number of years. They weren't structural. It was all the other things that you just don't do in a house when you're incapacitated, and that's why a POA was involved. So we did our due diligence when we bought the house, and we knew what we were going to have, a rough idea of what we were going to have to do. You never know till you start. And I tried to make this point, and the second point was there's not always a 3%. I've done a lot of deals where I've only get 2%. So I'm sorry that you're kind of operating on information that's 3 or 4 years old and what's happening in this market right now, and giving where Zillow and Redfin and these major players are coming into our market, there's a lot of pressure on commissions that real estate agents are able to get for their properties. So don't take that as gospel.
No, and I apologize if I made it sound like everything is 6%. It's just that on the MLS sheet, it's specifically listed 3% for commission for each of the buyer and seller agent. And that's why we looked at it as that 3%, because it's specified that 3%. The property owner also has stated, he paid that amount for that condition of the property. And I didn't view it, so Nick would have to explain. But if that property owner repaired some of these issues that he said were deferred maintenance at the time of viewing, and Nick will have to explain what he saw at the time of viewing, if these had been repaired or not repaired. So even if someone purchased a property at $375, and it had deferred maintenance, let's say they put in all new flooring, all new, whatever the condition may be, that would be a fair condition at the time of sale, but it may be an average or good condition at the assessment date. And Nick is the one who viewed it, but I want the board to understand that aspect of it too, is if you make improvements to something after you purchase something, then that property's value would increase in some situations. Not always, but in some situations, it would increase. Just like if you tear out basement finish after you purchase something, it might decrease. So we have always the time of the purchase, and then you have the assessment date of each calendar year.
So I have just a couple quick questions for the property owner. Do you have a family or personal relationship with the woman who owned the home previously?
No.
How about the power of attorney?
No.
Did you personally participate in the negotiation of the sale price?
Yes.
Okay. And I guess I don't want to put words in your mouth, but was it your testimony that you were able to pay a lower sales price because you did not have to pay a buyer's agent a 3% commission?
No.
And so was there any discussion, and remember, you're under oath, but we're taking you at your word, but was there any discussion with the seller about adjusting the purchase price due to the fact that only 3% commission was going to be paid on the sale?
No, just the opposite. The discussion was around the condition of the property. And as referenced by Amy, the POA was not familiar with the condition of the property. And so when we toured it, we actually toured it 3 or 4 times before we put our offer in, to kind of get our arms around what things had to be done. And we submitted a list of, I can't remember if it's verbal or written, but we went through a list of everything that needed to be updated or remediated in this house to make it, to justify the purchase, to justify the purchase price that they had. established for this.
So we heard the testimony about the deck and the screen porch that was rebuilt, and for which the building permits were pulled. Were there other update projects made since the purchase for which a building permit was either not pulled or not required?
Not required.
And what kinds of projects were those?
Painting, removal of a fireplace, which is referenced by Nick. It was a goofy fireplace. It had an out wall, and then this suspended fireplace was just hanging in the middle of the difference between the living room and the dining room, and it screwed up the flow. The house was extremely dark, and so we added lighting. The ceiling fans didn't work, so we added workable ceiling fans. And I reviewed these with Nick when he came through and pointed out that we had a deck with a screen porch and that was going to be redone. And I think I lost that battle 2 years ago, so I don't think I'm going to make points again. But what I'm really asking for today is just the fact that I got doubled up on. And that's really what we seem to have gone back to. How did Nick arrive with the original assessed value, which I didn't object to. I thought about it, but what I'm really here today to talk about, and the point we're really discussing is, in a catch-up year, you've already caught me up when I just purchased it. And then to do another one on the increased assessment is where I think there's a slight flaw in what we're talking about. But I'm willing to talk about the original sale if you...
Okay, well, we're at a point where we've got to draw this to conclusion. I think we've heard the arguments and concerns. So anything else that the board would like to ask?
I can make another quick statement if you need.
Quick?
Yep. So I just want to verify real quick again, we assess as of what's there January 1st every year. The property was purchased on November 6th. When I did do the full walkthrough in December 13th, it did have some cosmetic wear and tear when it was purchased, but they were in the middle of some of the updates and repairs when I did do the walkthrough December 13th, so that's why we had listed the interior as average condition, since it was the repairs they did make between the purchase and January 1st of 2020 did bring it back up to a better condition than when they purchased it. And so the reason for the assessment increase for 2021 is due to that permit that was pulled in and the work that was done in 2020.
Okay, thank you. That was pretty quick. Discussion from the board? Go ahead.
Yeah, I been hearing for several years that commissions are negotiable now. It's not, and Mr. Lynch said that he reduces his. The commission you pay is also for a service, and I think you said the house had been on the market for 6 days. Every house in my neighborhood where they're going through a conventional process has been turning over in 2 days, and this is for like 3 years. So that could be part of the service that he did not get, was the quick turnaround of the house itself. I think since it's negotiable, the time on the market, I have a big problem with the arm's length restrictions and the 3% commission being put back in. I don't agree with that.
I agree with that comment. Just want to expand a little bit. I mean, I think, we only have one person here who participated in the negotiation of the sale, and that's the property owner. We're able to ask him questions about it. He testified as to, briefly as to the impact or maybe the lack of impact that had. But I think that's right. I mean, it's clear that he didn't have a relationship with the seller. He wasn't able to get a friends and family deal on the house. The fact that he didn't pay a buyer's commission, that may be still a little bit unique in the market, but he did testify that the sale price was arrived at not because the owner didn't have to pay a commission to the buyer, which is a little bit of a benefit to the seller, I think. They get to keep more of the purchase price if they don't have to pay a full buyer's commission. But he testified that the sale price was based on the condition of the property. So what I'm hearing from the owner about the way the sale was negotiated is that the fact that there was less commission on the deal didn't have an impact, and it was more a negotiation over the condition of the property. So to the extent that that influenced the assessor's position, I mean, I can understand that under certain circumstances, a buyer may be able to negotiate a lower price by telling the seller, hey, you're not going to have to pay a full 6% commission on this deal. Why don't you give me a little break on the deal? But that's not the testimony today, and we don't have testimony from anyone other than the property owner about how that deal was negotiated. And so based on the sworn oral testimony, I believe that the increase in the assessment value based on that 3% adjustment is incorrect. But it does sound like the improvement to the deck and the screen porch certainly factors in to the assessment, since that was a building permit pulled and work done to improve that. So in my view, that 3% should not increase the assessment, but there is some, obviously some issue with the real improvement for which the permit was pulled. So anyway, that's where my thinking on this issue is coming down.
Can I make a quick comment?
They're in deliberation.
Oh, sorry.
Too late, thank
Okay.
you.
Yeah.
Just to remind the board that we're
Wait, you're done.
in the position now where we're looking at the evidence. And as we look at evidence, as the Supreme Court has directed us, sale of subject property is a key factor. So I think what we're focusing on here is a correct thing that we have to look at. Is the sale of the subject an arm's length transaction under the definition that we would typically expect? It's been pointed out that things are changing in the real estate world, that a 6% commission that was a standard for years may not be the standard any longer. So just reminding us that sale of subject is one of the key factors. Has the assessor or the taxpayer proved that the sale of subject is the correct value, I think is a key point that we have to look at in this particular case. So with that, I'd open it up to other discussion. Matt, do you have anything you'd like to add?
Nothing that hasn't already been said.
Eldon, we can't see you. Hopefully you're still listening.
Yeah, no, I'm still here. I guess the one point I would like to hear the assessor just sort of reinforce, I guess, is that the complaint seems to be about the doubling up in a very short amount of time. And as I understand, this year is supposed to be a maintenance year. But I guess my question would be, during a maintenance year, is it standard procedure to just look at permits that were pulled? So everybody else kind of gets a maintenance thing, but anybody that had a permit to do some improvement would get the new assessed value?
Could you please answer that for us, Nick?
Yes, in a maintenance year, we still review all permits and any new construction. So if there are any actual changes to a property that would affect the value, those changes are still made. The values are just still based off 2019 sales, but it's any work done to the property is still reviewed for every property in the city.
Okay.
Yeah, you have in a maintenance year, we're still using all of the cost tables and the markets that were derived as of 1/1 of 2020. So if you add a deck that wasn't there before, it's still pulling in that same cost as if it was 2020. It's not pulling in the value as of 2021, if that makes sense.
Does to me.
Okay,
Is that
thank
okay?
you.
Any other questions? I think we're at a point then where we have to make a determination.
I'd like to make a motion.
Please do.
I would move that the value be adjusted as follows. 375 was the sale price in November of 2019, so as of January 1, 2020, that would have been a recent market sale. And then this year, there was an adjustment made, $9,800 for the deck. So if we add the $9,800 to the 375, I think that gives us 384.8. Is my math right? And I would move that the assessed value be set at that because the 375 was an arm's length sale according to the testimony of the homeowner. So there should not have been an upward adjustment in 2020, but the upward adjustment in the maintenance year for the addition of the deck at $9,800 should be kept in the valuation. So my motion is for 384.8 based on that.
I'll second that.
We have a motion and a second. All those in favor signify by saying aye.
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 Opposed? Hearing none, let the record note that the assessment has been adjusted in total to $384,800 for Mr. Lynch's property at 2603 Placid Street, City of Fitchburg. And I'm sure the clerk has the parcel number so that a proper notification can be prepared. Mr. Lynch, before you leave, she will give you a completed indication showing that the assessment has been adjusted to that amount. And if you're unhappy with that determination of the board, there's information on the back of that notice as to how you can continue the appeal process.
Thank you.
Thank you for your time this morning. And I have a general question. How long did you work for Marshall Erdman?
15 plus years.
Do you know Dan Rosine?
Yes,
Dan's a good friend of mine. Worked with him for a number of years.
they were absolutely the best years of my life.
Ditto. I was there 30 years.
Now, does the board need a break? Does the board need a break? I don't. We're still good? Eldon can take a break and we can't tell, so he's in a good position.
I actually would like to just take a few minutes laboratory break, if that's okay.
My watch shows it's 10:48. Let's come back at 10:55. It'll be 7 minutes.
All right, thank you.
Thank you. Noisy. Back on the air. Next on our agenda is an appeal from Roger and Kathleen DeChamps Revocable Trust. Is representative here for that appeal? I believe, as you saw in the last appeal, we're going to ask you and the assessor's staff that are going to be testifying to stand to being sworn in. So I'd ask the clerk to do that.
Okay, raise your right hand. Do you solemnly, sincerely, and truly declare and affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, and this you do under the pains and penalties of perjury?
I do.
Okay. And can I have you state your name and address, please?
May I sit down?
Sure, you can sit down.
Excuse me, my name is Roger DeChamps. My address is 3036 Woods Edgeway, Fitchburg, Wisconsin.
And this is parcel number 0609-054-5276-4. Land improvements were 6,300. I'm sorry, land was 6,300. Improvements were 42,700 for a total of 485.
Just as in the past, I'm going to read briefly into the record how we're going to proceed. Under Wisconsin Chapter 70 of the statutes, it gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving the assessor erred in determining the value of your under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. Those standards are: the best evidence of value is a recent arm's length sale of the subject property. Next, sales of reasonably comparable property. And then all other approaches to value, which would include the income approach on income-producing properties and cost approach on special purpose or unique properties. At this time, please share any exhibits that you'll be reading into the record.
Okay. Good morning.
Just a second. Do you have exhibits?
Yes, I do.
Okay. Do you have copies to present to the board?
I'm supposed to present the physical copies. I submitted them with the objection.
Okay, so you're going to present this. I'll hold it up. We have an objection form that has.
That's correct, yes.
Okay. We'll identify this then as Taxpayers Exhibit 1. And I understand you are going to then read from those exhibits to create your record. Is that correct?
Yes, I can, yes.
Okay. So I will then mark the attached exhibits that are attached to his objection form as Taxpayers Exhibit 1. There are 4 pages, so it'll be A, B, C, and D. Before you begin, I'd like you to briefly describe your property so that we know what kind of property we're talking about this morning.
Excuse me, just one quick question. This property is owned by a trust?
Revocable trust.
Are you the trustee?
According to the city records, in the process, I discovered that when we purchased it, they did not record the deed properly. But somehow the city records have it as a trust, which it should be. The actual deed is in my and my wife's names, not as a trust. So it's something I have to get straightened out. But for tax purpose, for the city records, it's as a revocable trust.
Okay, thank you.
So it's your personal residence?
Yes, it is, yes.
Okay. Please begin.
Okay. Could I just say first that unfortunately I went swimming this weekend with my hearing aids in, and I'm having a terrible time hearing, particularly the assessors. I can't understand anything that you've said, so if you could speak up, I'd appreciate it. Okay, I am confused when you say 3 exhibits.
One exhibit marked pages A, B, C, and D. Taxpayers' objection form.
Oh, okay.
A.
Okay.
Next 3 pages.
Okay. The next 3 pages are I'm sorry, I may not have these in the same order that I submitted it here. I shuffled my papers. The first exhibit is 5703 Wilshire Drive. It had a sale price of $460,000 and an assessed valuation of $331,100, which means that the assessment is 72% of the market value. The second exhibit is 5882 Persimmon Drive, Fitchburg. It had a sale price of $728,000 and an assessed value of $540,400, which means that it's assessed at 74% of sale price, which I'm assuming to be market value. And the third one is 3052 Oakleaf Circle, Fitchburg. The sale price was $590,000, and the assessed value is $478,400, which means that the assessed value is 81% of the market value.
Is there anything else?
That's all I have to submit as exhibits.
Okay,
My objection is not to the market value calculation, but to being assessed at nearly 100% of market value when I see practically every property being sold in Fitchburg is selling at a price way over the assessed value. So I'm, I understand this is because of the seller's market right now, that prices are going crazy, but I just object to being assessed at a much higher ratio than most properties in Fitchburg. The previous owner, we purchased about 6 months ago, and the previous owner updated the kitchen and baths about 5 or 6 years ago. And actually, my wife thinks some of the updates are out of style already, but anyway, as a result, the property is deemed to be newer than it actually is, and the assessment software comes up with 97% of what we paid 6 months ago. I think a reasonableness check needs to be applied when the software comes up with an assessment that's so out of line with what the rest of the city is paying. And my concern is what happens in the future. When I asked the assessor when I could expect my assessment percentage to be similar to what other properties in Fitchburg are paying, he said that an adjustment factor specific to our condo development, Seminole Village, this adjustment factor would be calculated to bring assessments up to market value. So that means the same adjustment factor would be applied to our value, which is already at nearly 100%. It seems to me that would only compound the inequity. And I think that an adjustment should be made starting in 2021, and that it would be only fair to do so.
is there anything else, sir?
No, there's not.
Okay. At this point, then, we'll ask the assessor's representative to present their evidence as how the value under appeal was established.
Thank you. Kaya is currently distributing the written information summarizing the basis for completing the 2021 assessment of the subject property. And I will briefly summarize the written documents with oral testimony once she finishes handing those out. Thank you.
Please let the record note these are being marked Assessor's Exhibit 1. Again, it's multiple pages, so the pages will be lettered alphabetically, starting with A through the end. Please continue.
On the first page of Section 1 is a summary of my qualifications to complete the assessment. I'm Nick Hare. I'm employed with the City of Fitchburg Assessing Office as a residential appraiser. I have an Assessor 2 certification, which expires February 28th of 2026. I have worked in real estate for over 15 years and have been in the assessment industry for over 5 years. There are additional qualifications listed below. Part A outlines the standards for establishing value. State Statute 7032 outlines that the property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained, therefore, at a private sale, when such sale conforms to the definition of recent arm's-length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used in determining market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a maintenance assessment role, the estimated level of assessment is approximately 95%. On the next page, you will find a location map illustrating the subject property's location. And it is in a condo subdivision off of McKee, just northeast of McKee and Seminole Road. The next few pages are the property record card that contains specific data on quantitative and qualitative physical characteristics of the land and improvements for the subject site. To note some of the more significant data, the first page shows that the property is a residential attached condo located in the Seminole Village Condos neighborhood. The second page shows the building permit history, which shows a permit for siding replacement and remodeling totaling $185,900 in 2016, and a permit for landscape lighting of $3,500 in 2019. The sales history, which shows the owner purchased the property for $500,000 in November of 2020. We have it listed as not market, given it was a word-of-mouth sale and it was never listed on the MLS. Per the owner, an appraisal was completed, which gave a value of $500,100. In the notes section, there was an open book appointment on May 12th of 21, which included a full walkthrough. Based on the walkthrough, there was an adjustment granted based on the changes from the inspection, which reduced their 2021 assessment from $499,900 to $485,000. The land use, which shows there is a negative 10% adjustment to the land value given the subject backs to McKee Road. On the third page, I will note that the subject is a contemporary style residence, 2 stories in height. It contains a total of 3,422 square feet of living space, which includes a basement finish. It was built in 1994, and it had significant remodeling completed in 2016. It is a construction and quality grade of B+ property, and its overall condition, desirability, and utility is rated at good. There are other detailed information on the physical attributes contained in the record card. The fourth page shows a sketch of the property. The next 2 pages of the document are the market valuation detail. The market valuation detail summarizes the assessment calculation as completed by our automatic valuation model. And given this was a maintenance year, the model is based on Volume 2 of Wisconsin Property Assessment Manual and 2019 arm's length sales. The next page in the document is a map that locates the subject and recent reasonably comparable arm's length sales. The following page is a sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. The addresses of the properties are 3037 Woods Edge Way, 2986 Woods Edge Way, and 2974 Woods Edge Way. The sales dates of each one for comparable 1 sold in May of 2020 for $540,000. Comparable 2 sold in June of 2019 for $420,000. and comparable 3 sold in July of 2020 for $400,000. The report shows photos and lists comparative data that demonstrates the sale properties are reasonably comparable to the subject. The styles are 2-story contemporary condos. The subject and sales gross living areas, including the basement finish, range from 2,390 square feet to 3,695 square feet. The effective year built ranges from 1993 to 2015. Other data is listed demonstrating that the sale properties are reasonably comparable to the subject property. The report adjusts the sales prices for differences such as the lot, building attributes, age and condition, market location, and detached structures, if any. The adjusted sales prices are $511,500, $546,800, and $514,200 respectively. The adjusted sales prices of reasonably comparable properties indicate that the assessed value of $485,000 is a fair estimate of the market value of the subject property as of January 1st, 2021. So in summary, there is a recent sale of the subject property. However, we did not label it as arm's length given it was not listed on the MLS. Consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using a valuation model based on Volume 2 of the manual and 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties and adjusting for differences between them and the subject property. Thank you. That concludes my presentation.
Thank you for your testimony. Just looking at your exhibit, trying to make sure I have all the information absorbed, since it's a fair amount that was given in a short period of time. Thank you for being concise. At this point, I would open discussion up from the board for questions on the exhibits and the information that has been presented.
Yeah, I have a question. I think the property owner is essentially making what I would characterize as a uniformity argument, which is a difficult one to make. But he points to a number of sales that took place in 2021. Does the assessor use 2021 sales? Some of these were I think in April is when they closed. Is that information part of what the assessor reviews in making the assessments? And I believe it's as of January 1 of 2021. So if these sales took place after that, would they be in consideration for this year's assessment?
We have not begun to review the sales that occurred during 2021. Those we will review for 2022. So the sales, I believe some sales included in the comps were the ones that were reviewed in 2020 that would lead up to 1/1 of 2021. But because this is a maintenance year, that the increase in the market or decrease, whatever the market is happening, we are not making that market adjustment yet for the 2021. So,
But as to particular properties sold in 2021, when it comes to doing 2022, you'll have records of what those sales were that took place this year,
Correct.
and those properties that there was an actual sale,
yes.
which is always the best evidence.
So we will review each sale. Once this assessment roll is done, we will start reviewing the sales that occurred during 2021. And then we'll also look at the sales that occurred in 2020, because this is a maintenance assessment year. So we'll have 2 years of sales that we will look at. We'll look at that time adjustment. We also look at sales per each neighborhood and then each neighborhood group. So we would look at this condominium complex as its own neighborhood and review the sales that occurred within that neighborhood. And then we will look outward to the neighborhood grouping of other condominium neighborhoods that are in the condominium group, neighborhood group. So these 2021 sales we have not reviewed yet. We do not know the information on them. We don't know if the seller had finished off basement finish that we might not have. We don't know if they did a remodel without a permit. That's all part of what we discover when we go out to a sale. So it might be recent arm's length, but it might not be for ratio, because they may have done improvements to that property without building permits or without letting us in, things like that. So that's why we review the sales every year.
So just to get to the calculation that was presented by the taxpayer, he's looking at 2021 values and comparing it to a 2019 base of sales. So if there's been inflation in those 2 years, you would certainly expect to see a lower ratio of sales to market value than if you were using current year sales or even 2020 sales in your reflection of the assessments.
Correct.
Okay.
And we know that the residential that occurred during 2020, that residential market is increasing tremendously, other than maybe on the high-end properties,
Okay.
the very, the executive mansions.
Mr. Lynch, did you have anything that you wanted to ask of the assessor or of the board?
Okay. Well, I just think it's unfair that my assessment is based on 2021 values when most of the city is based on 2019 values. And that's, that results in this, assessment ratio being so much lower for properties that, for most of the city. And my concern is, from what Nick tells me, the adjustment factor will be applied to all properties. So that's only going to compound the inequity. When I'm already at 100% and somebody else is 80%, and you adjust both properties with the same factor, that's only going to compound the inequity. My question is when will an adjustment be made?
We don't have an answer to that question yet because the assessor has to look at the issues and deal with them as they change, and it's been a constant series of changes.
Yeah. The point is, I am not objecting to the calculation that the software came up with. I'm objecting to the fact that I'm assessed at a higher percentage than most of the city of Fitchburg.
Understood.
Can I?
No, I think we got it.
Okay.
Any other questions from members of the board? Okay, again, going back to the rules of evidence. Recent arm's length sale of the subject property is the key factor the board needs to consider. The assessor has said that they didn't think your sale was arm's length because it wasn't exposed to the open market. Yet I see on your objection form, you tried to sell the property in July of 2020, and you're asking $520,000. Did you then pull it from the market?
No, I've owned the property since November of 2020.
Okay.
And
so it was on the market in July of 2020 at $520, and you bought it later in the year for $500.
Oh, I'm sorry. Right, July of 2020, and then we bought it
in November.
That's when the seller originally, it was not listed with MLS, but he put the word out in the condominium development that it was for sale in July.
So our concern is, and we have to determine, is that a fair market transaction between willing buyer and willing seller? Were you under any duress, or was the seller under any duress to sell the property?
No.
Not that you're aware of?
No.
Were you forced in any way that you were under any kind of duress that you had to buy the property?
Yes, because of COVID, we wanted to move to Fitchburg from Milwaukee because our daughter was working from home but needed childcare. So that put a little pressure on us to find a property, and I will say that we did talk to the seller and say, hey, you know, you're not paying the 6% here. We should be able to negotiate the price. And they said, we don't have to pay 6%. We can sell this property without paying any commission. So they weren't willing to negotiate on the basis of 6%.
So they demanded a price and you agreed to pay it?
Well, they were asking, well, originally they were asking what they paid for it plus everything they put into it. And it's generally known that kitchen and bath improvements, you only get about 60% back when you go to sell. So we negotiated on that basis. And the property was assessed at, I think, at $496 at that time. And so we ended up negotiating the $500.
So there was arm's length negotiations between you and the buyer?
Yes, definitely.
Okay. Thank you for that clarification. So, as a board, we have to determine, was that a fair market sale? And with that clarification, my clipboard jumping, I think that gives us a little better indication as to how the sale transpired. Any other questions by the members of the board for discussion? Eldon, we can't see you again. Is there anything you would like to add?
No, no questions for me.
Okay. I think we have an arm's length transaction that fits the time frame of the assessment as identified by the assessor and as by the rules of evidence. When we have an arm's length transaction negotiated between willing buyer and willing seller, that gives us a sound basis for, as the assessor used in determination of the assessment. And he's actually slightly under the assessed value, or the assessed value is slightly under the actual sale price based on the assessor's actual inspection of the property. So I think that gives us a strong basis for our determination. So at this point, I would open the board to a motion as to what we should do.
I move to sustain the assessor's value. I think the taxpayer attempted to bring to us information about a uniformity issue, but because the sales are from this year, they haven't been able to be absorbed and taken into account by the assessor, so I can't use that as a basis to find that there's an issue with uniformity. We had testimony from the assessor about that and how sales are factored in and when they're factored in. So without any presentation about a failure of the assessor to uniformly consider sales within the time frame that the assessor acquires the information for purposes of 2021 assessment, we don't have a uniformity issue in my view. I can appreciate the taxpayer's concern, and I think, it sounds like the information that was presented today will be taken up by the assessor and probably can expect to see adjustments to some of these properties in the next year, but the assessor didn't have the benefit of that information when putting together the assessment roll this year. So it just isn't something that the assessor is able to. The assessor can't pick up sales in the current year and process that, but it'll be adopted in the next year. So I appreciate the concern, but it isn't something that causes a uniformity concern this year. So for those reasons, and taking into account what the taxpayers presented, I think the assessment should be confirmed and sustained.
Second?
At the value of?
Oh, excuse me. The current assessed value is $485.
Second.
We have a motion and a second. All those in favor, please signify by saying aye.
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 Please let the record note that it's a unanimous decision. Mr. Lynch, we thank you very much for your presentation this morning. And as I've told the others, the clerk will be giving you a notice of determination this morning. On the back of that notice of determination is an opportunity for other avenues of appeal. It describes them and tells you how to start that process if you're so interested. So we thank you very much for your testimony this morning, and I guess the clerk's got the information for you already.
Could I just ask the assessors when I can, can expect my assessment percentage, excuse me, when I can expect that my assessment percentage will be brought in line with the rest of the city? That's all I'm asking.
Yep, so for this year was a maintenance year, and we revalued for 2020, but 2021 was a maintenance year. So for 2022, we will review all of the sales, and then each neighborhood will be brought in line with what the sales are within that neighborhood or that neighborhood grouping. So that will occur for 2022, so you should get, probably April, May of next year. You should get a change of assessment notice. All property owners should, and at least that's our intent right now, is to adjust all the values again for 2022. And so if those sales that you referred to, we will, I guess, we call them reviewing the sales, but we'll find out if they're arm's length. That's the first question. And then we need to verify the data on those sales. So we do full walkthroughs of the properties when they sell, as long as the property owner lets us in. And if they don't let us in, then we'll use the best information available by reviewing MLS listings and making sure all the data is captured.
Okay, my question is,
Well, we need to get the board continuing. I'd encourage you to call the assessor's office and talk to them so that you can get your questions answered, so your concerns are addressed. We have other people that are waiting. We need to continue our appeal session this afternoon.
thank you.
Thank you.
So these are determination forms in duplicate. It's showing your name, your address, your personal, and your address. This is the 2021 assessment for this year, and this is the final assessment that the board determined correct. So I'll need you to sign and date each copy. You'll get to keep one, and I'll have one for my record. Today's 6/7/21. Just point out here, if you wish to appeal what the board has determined today, this is the process on how to do it, okay?
Thank you.
Mr. Adolphson?
Good morning.
Morning. Would you please identify yourself for the record?
Oh, my name is Edward Adolphson. I live at 5711 Modern Air Street, Fitchburg, Wisconsin.
Thank you, sir. At this point, I'd ask the clerk of the board to swear in all parties who will be testifying. If you'd please rise.
Do you solemnly, sincerely, and truly declare and affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? And this you do under the pains and penalties of perjury.
I do.
Okay, thank you.
Today we have Edward Adolphson, address 5711 Modern Street, parcel number 0609-162-6599-1. This is a residential property, and the total assessed value is $359,700.
Thank you very much. As we start this process, I think you've heard the statement I read.
I'm sorry. The total assessed value is I'm right. Yep, 359. I'm sorry. Sorry to interrupt.
359,700. That's what's on the objection form.
There's only,
Just a second, sir.
okay.
Read this information to you so you know what our standards are as we continue. Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness. The Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving that the assessor erred in determining the value under appeal. The total value, I skipped that word, it's important. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. Those standards are recent arm's length sale of the subject property. Next would be sales of reasonably comparable property. Then all other approaches to value, which would include income-producing properties and the cost approach on special purpose properties. At this time, please share any exhibits that you will be reading into the record. Do you have any exhibits?
I have
this morning?
two. It's going to be the 2021 Notice of Assessment
Okay,
dated April 27th of 2021. The second document comes from the Wisconsin Department of Revenue regarding new construction and improvement maintenance.
okay. I have copies of those in front of me. I will mark those for the record as taxpayers' exhibits 1 and 2, not including your objection form.
Okay, the basis of my objection is this notice of assessment went up $12,200, and it was, the reason for the change was new siding. I had 35-year-old vinyl siding on the house. It became brittle, cracked, and I had it replaced not with 35-year-old new vinyl siding, just new vinyl siding. And then to that, under the Department of Revenue, it says, normal home repairs and maintenance generally prevent property values from falling and usually do not warrant a change in assessment. And so I'm asking the board to go back to my 2020 year assessment of $355,400.
So you took off vinyl siding, what did you replace it with?
Vinyl siding.
Okay. Is there anything else you'd like to add?
No, as a matter of fact, I'm hearing this is a pretty simple case. I want to just about keep it just
We
simple.
appreciate that, thank you. Okay, next we'll enter into the assessor's office staff for their presentation of information. And as in the past, we have an exhibit that'll be presented. I'll mark that assessor's exhibit 1 with the pages set in alphabetical sequence A through whatever the number is, or letter is.
Thank you. Kai is distributing the written information summarizing the basis for completing the 2021 assessment of the subject property. I will briefly summarize the written documents with oral testimony. On the first page, section 1 is a summary of my qualifications to complete the assessment. I'm Nick Hare. I work with the City of Fitchburg Assessing Office as a residential appraiser. I have an Assessor 2 certification, which expires February 28th of 2026. I have worked in real estate for over 15 years and in the assessment industry for over 5 years. Below are additional bullet points of my qualifications. Section 2, the purpose states the purpose of the assessment and standards of establishing value. The purpose is to estimate the full value, often referred to as the market value of property as of January 1st, 2021. Part A outlines standards for establishing value. State Statute 7032 outlines that the property shall be valued in accord with the Wisconsin Property Assessment Manual at the full value which could ordinarily be obtained, therefore, at a private sale, when such sales conform to the definition of recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is to be used in determining market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as the systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a maintenance assessment role, the estimated level of assessment is approximately 95%. On the next page, you'll find a location map illustrating the subject property's location. The next few pages are the property record card that contains specific data on quantitative and qualitative physical characteristics of the land and improvements for the subject site. To note some more significant data, the first page shows the property as a residential house that is located in the Wildwood South neighborhood. The second page shows the building permit history, which shows a permit pulled in March of 2020 to reside the house. It also shows the sale history, which shows no recent arm's length sales of the subject property. The third page shows notes section, which shows that a drive-by inspection was completed July 16th of 2020, which captured the completed siding. And a full inspection of the property was completed on December 28th of 2018. The fourth page shows the land information of the property. And the fifth page will go over and also the next page shows the actual permit from the siding. Then the following page shows some information on the record card that I'll highlight. The subject is a colonial-style residence, 2 stories in height. It contains a total of 3,288 square feet of living space, including the basement finish. It was built in 1989. It is construction and quality grade C+ property. Its overall condition, desirability, and utility is average. And I will show in the assessment module, part of where the assessment value comes from is from the ratings of 5 different categories: equipment, kitchen, bath, interior, and exterior. And in calculating our assessments, if there is any type of updating or any type of work done to a house, that is often captured in those ratings. So say a kitchen was remodeled, we might change the kitchen rating to good or very good, depending on the quality of the remodel. So for this one, since the siding was replaced, the exterior rating was adjusted to the good. So the 6th page then shows a sketch of the property. The next page of the document is the market valuation detail, and the market valuation detail summarizes the assessment calculation as completed by our automatic valuation model. The model is based on Volume 2 of Wisconsin Property Assessment Manual and 2019 arm's length sales. The next page of the document is a map that locates the subject and recent reasonably comparable arm's length sales. The following page is a sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. Comparable 1 is 5721 Newton Street, which sold in May of 2019 for $340,000. Comparable 2 is 5646 Penwall Street, which sold in June of 2020 for $370,300. And comparable 3 is 2623 Richardson Street, which sold in April of 2020 for $365,000. This report shows photos and lists comparative data that demonstrates the sale properties are reasonably comparable to the subject. The styles are all 2-story colonial. The subject and sales gross living areas, including the basement finish, range from 2,004 square feet to 3,288 square feet. The effective year built ranges from 1982 to 1992, and the other data is listed demonstrating that the sale properties are reasonably comparable to the subject property. The report adjusts the sale prices for different attributes such as the lot, building, age and condition, market location, and detached structures, if any. The adjusted sales prices are $382,100, $398,000, and $371,200 respectively. The adjusted sales prices of reasonably comparable properties indicate that the assessed value of $359,700 is a fair estimate of the market value of the subject property as of January 1st, 2021. So in summary, there is not a recent arm's length sale of the subject property. Consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using a valuation model based on Volume 2 of the manual on 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties adjusted for differences between them and the subject property. Thank you, and that concludes my presentation.
Can I just make a couple points quick that he kind of went over very quickly that I think are key factors in this property? When someone makes changes like to the exterior of a home, like a new roof, siding, things like that, we find that buyers will, they pay more for that if it's got brand new siding on. So in this case, that exterior rating was changed from average to good. If in the documents you go to the market valuation detail page, you can see, that's kind of like your cash register receipt. It works its way all the way through. But each of those ratings, that equipment rating at average has a modifier of 1. But the exterior rating of good has a modifier of 1.02. So that's adding that 2% to that replacement cost new. And that's how that valuation change is. Originally, when the original value was set, Nick had changed the exterior rating to good and also the effective age by 3 years. But during open book, he said, nope, the effective age doesn't get changed 3 years. It's just, we're just going to change it by that rating. And so the rating went from average to good, and there was that open book change, reducing that down for that consistency purpose.
Okay. Questions from the board? Any questions you'd like to ask the assessor?
No.
Okay. Thank you. If we have no discussion, we have to make some up. Just kidding. Again, the bottom line becomes what's the current value as of the date of assessment. As we look at the information presented, the assessor didn't just take the $13,000 that the building permit indicated and add it to the assessment. They actually looked at trying to be uniform in the process by adjusting, as they would any other property, in the cost system, market valuation cost system developed by the Wisconsin Department of Revenue. One element in there which was the exterior condition and reflected the change that was made. Based on that avenue, I think that the property received reasonable treatment as far as, in my opinion, the property received reasonable treatment as far as the adjustment that was made. And yes, I do recognize it says normal home repairs and maintenance. But is this normal home maintenance as defined in the Guide for Property Owners or the manual? No. Normal home maintenance is not having a contractor come in and do extensive changes to the structure of a home. So even though that is the published guideline in the Guide for Property Owners, I don't feel it fits in this particular case as being the standard that has to be applied in this appeal of the evaluation. So those are my comments. I'd also like to hear other comments from the other members of the board.
Well, just to agree with that, and I know the IRS isn't always right about everything, but they publish a manual on what you could deduct when you sell your house, add to your basis, and what they consider improvements versus maintenance, and new siding is considered an improvement. Again, not necessarily the rule that we live by, but when you sell the house, if you had to pay capital gains, you could increase your basis and pay less tax. So save your receipts from your siding project for when that happens down the road. So again, it's just another indicator to me that this probably falls on the side of improvements and not just routine maintenance.
Thank you. Anything else? Well, hearing nothing else, then I'd open the discussion for a motion. Nobody else will make it. I will. After reviewing the evidence as presented by the taxpayer and the assessor, I make a motion that we sustain the assessment at the current determined value after the open book at $359,700. This is for the property at 5711 Modern Air Street in Fitchburg.
I'll second the motion.
We have a motion and a second. All those in favor, please signify by saying aye.
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 Against? Please let the record note it was a unanimous decision. And Mr. Adolphson, as we've told the others, if you're unhappy with our decision, the clerk will be giving you a statement indicating the determination of the board. On the back of that statement are other avenues of appeal if you're so interested in following them. It gives you some guidance as to where to start. I thank you today for coming in. I'm sorry we didn't find in your favor, but I think we have to follow the statutes, and in this case, I feel we reached a conclusion that your home exterior was improvements, not maintenance.
So I have two forms here, they're in duplicate. Got your address here, your name and your address. It's got your parcel number, and it shows what you were assessed at. And it's showing that the board is approving it as staying assessed at that value. If you wish to appeal, this is how you do so. Okay, so I'll just need you to sign and date both forms. One form is for you and one form is for my records.
Good day.
Madam Clerk, is our next appellant here?
Vivek Praharakran. No?
Good morning. I'm glad I can still say it's morning. We're running a little late. We're sorry for that.
Okay.
Thank you for your patience.
Sure.
Would you,
May I read it?
please?
This address is 5829 Dolly Drive, parcel number 060905171222-8 and 0609-051-7112-0. And it was assessed at a total value of $1,474,500.
If you would, please, sir, state your name for the record.
Vivek Prabhakaran.
And we're going to ask you and the assessor staff to please stand as we swear you in to present testimony.
Raise your right hand. Do you solemnly, sincerely, and truly declare and affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? And this you do under the pains and penalties of perjury.
Yes, I do.
I do. Nick Hare, City of Fitchburg residential appraiser.
I do. Amy Mercer, assessor.
Thank you. This is a residential property we're talking about this morning.
Yes, that's right.
And as with all the other cases, I believe you've heard this, but I'll share it with you anyhow. Wisconsin Statute, Chapter 70, gives the assessor the presumption of correctness. The Supreme Court has ruled to overcome that presumption, you need to present sworn oral testimony proving the assessor erred in determining the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. Those standards are: best evidence of value is a recent arm's length sale of the subject property. Next would be sales of reasonably comparable property. And last would be all other approaches to value, like the income approach on income producing properties and the cost approach on special purpose properties or unique properties. At this time, please share any exhibits that you will be reading into the record.
I believe I sent the objection to the property assessment.
Okay. I have a substantial packet that you submitted.
And then I have,
As I said, this is sworn oral testimony, so you have to determine for us what you're going to put in the record. And I see an appraisal. If the appraiser not here, as I said before, we'll accept it as information, but it's not part of the sworn testimonial record. So we're going to ask you, as you look at the information, it's important to you to present that you provide sworn oral testimony on the value. Okay?
so, yeah. So the bank assessment, or the bank appraisal of the property, I think that you should have a copy of that. And we purchased the property in October of 2020 at $1,225,000. The bank appraisal came in at $1,274,000. And which is quite substantially lower than the city assessment of $1,474,000.
Okay?
And the bank assessment, I believe, was done based on 6 comparable properties.
Again, the bank appraiser is not here, so
So this is the report from the bank that I'm submitting as bank appraisals report.
you're telling us then that there's been a recent sale of the property that you were a party to.
Right.
And as a recent participant in that sale, can you tell us a little more about the transaction?
Well, we offered, they accepted our offer, basically $1,225,000. I believe that's the previous owner. It was the first time. He was the one who built the property, Patrick Baxter, and I think they were basically downsizing, is my understanding.
Mr. Baxter, I believe, built a new house in Fitchburg,
Oh, maybe.
bigger house.
Oh, did he? I thought he moved to a condo out in downtown or something, is what I was told, but.
It might have been, I don't know for sure.
That was the son.
Oh, okay.
Yeah.
Doesn't say junior, I didn't know that.
Yeah.
Could you describe the negotiations that we were involved with?
It's arm's length. I don't know but Mr. Baxter personally or anything, so.
And Mr. Baxter wasn't, to your knowledge, under duress to have to sell the property?
Not that I'm aware of, no.
And financing was arranged typically, you'll see a bank appraisal, so I'm assuming that was the case?
That's right.
Were there any other considerations financially or other that were offered or provided in the transaction?
No.
Okay. Is there anything else you'd like to add in how the transaction occurred?
No, it's pretty standard. It was a jumbo loan, I guess. That was about it.
So you and your family members searched the market and found this house and felt it was something that you could move into with your family?
We lived in Fitchburg for 12 years in 3029 Boshard, which is about only a mile away from this property. So we knew, we were wanting to stay in the same area, so.
Okay.
So that was part of the consideration.
I guess we'll turn it over then to the assessor and the assessor staff for their guidance as to how they establish the value and why there's a difference when there's an arm's length sale.
Thank you. I have, Kaya is distributing the written information summarizing the basis for completing the 2021 assessment of the subject property. I will briefly summarize the written documents with oral testimony.
Please let the record note this will be marked as Assessor's Exhibit 1 with the pages labeled alphabetically.
On the first page, Section 1 is a summary of my qualifications to complete the assessment. I'm Nick Hare. I'm employed with the City of Fitchburg office as a residential appraiser. I have an Assessor 2 certification, which expires February 28th of 2016. I have worked in real estate for over 15 years and in the assessment industry for over 5 years. Below is additional bullet points describing my qualifications. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as market value, of property as of January 1st, 2021. Part A outlines the standards for establishing value. State Statute 7032 outlines that properties shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained, therefore, at a private sale. One such sale conforms to the definition of recent arm's-length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used in determining market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a maintenance assessment role, the estimated level of assessment is approximately 95%. On the next page, you will find a location map illustrating the subject property's location. And it is one property that goes over 2 different lots. The next few pages are the property record card that contains specific data on quantitative and qualitative physical characteristics of the land and improvements for the subject site. To note more significant data, the first page shows that the property is a residential house located in the Harlan Hills neighborhood. The second page shows building permit history, which shows a permit pulled in June 2019 to replace the AC, and sales history, which shows the current owner purchased the property for $1,225,000 on October 28th, 2020. The notes section, which shows there was a Zoom inspection, sale review completed on December 9th of 2020. And the land information shows this residence is over 2 lots, and the record card for the second lot is included after this record card. The third page shows outbuildings, which includes a detached garage and a swimming pool. The fourth page highlights the structure is an executive mansion-style residence, 2 stories in height. It contains a total of 9,118 square feet of living space, including the basement finish. It was built in 2004. It is a construction grade and quality grade A+ property. Its overall condition, desirability, and utility is rated as average. There is other detailed information on the physical attributes contained in this record card. The fifth page shows property attachments, including an attached garage, open porches, and a patio. The sixth page shows a sketch of the property. The seventh page then shows information of the 480 square foot pool house. And the eighth page shows a sketch of the pool house. The following page, again, is a property record card for the second lot reflecting the land value of the second lot. The market valuation detail is on the next page. This details the assessment calculation as completed by our automatic valuation model. This model is based on Volume 2 of the Wisconsin Property Assessment Manual and 2019 arm's length sales. The next page of and then there is also the market valuation detail of the second lot, which shows the land value for that. The following page is a document that is a map locating the subject and recent reasonably comparable arm's length sales. The following page is a sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent arm's length sales. The addresses of the property are 3113 Kirkwall Street, which sold in February of 2018 for $1,220,000. Comparable to is 3123 Harlan Circle, which sold in June of 2020 for $804,000, and 5749 Dolly Drive, which sold in June of 2020 for $693,000. They are all two-story custom. The subject and sales gross living areas, including basement finish, range between 5,585 square feet and 9,611 square feet. The effective year built ranges from 2001 to 2005, and there's other data listed demonstrating that the sale properties are reasonably comparable to the subject. The report adjusts the sales for differences such as the lot, building attributes, age and condition, market location, and detached structures, if any. The adjusted sales prices are $1,571,800, $1,509,700, and $1,464,100 respectively. The adjusted sales prices of reasonably comparable properties indicate that the assessed value of $1,474,500 is a fair estimate of the market value of subject property as of January 1st, 2021. So I do want to address that there was an arm's length sale in 2020 for the purchase price of $1,225,000. However, given this is a maintenance year, we are still using the cost module based off of the 2019 sales, and we have not included any changes for sales in 2020. There was only, any changes would only be for discoveries made from the inspections. So with this property in specific, there was that Zoom inspection that I did make changes. There were several changes to the square footage, but the changes that I made actually had increased the assessed value. So what we did is we given the purchase price was lower than the assessed value, we didn't feel that the changes that were made from or discovered during the inspection, we should not be increasing the assessment, so we actually overrode the value to hold the assessment for from the 2020 value to 2021 value. We do realize that with some of these more executive style mansions, we've noticed in 2020 and any sales that we've seen in 2021, they are typically selling lower than the assessed value, but those changes will be reflected when we review the 2020 and 2021 sales for the 2022 assessment. We need to maintain consistency for all properties, given it's a maintenance year, and that's why it was not dropped, the assessment was not reduced based off that information of the sale price. So in summary, there is a recent arm's length sale of the subject property, but given it's a maintenance valuation year, we did not adjust any values based on sales in 2020. Consistent with Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment in the property using a valuation model based on Volume 2 of the manual and 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties, adjusted for differences between them and the subject property. If Amy doesn't have anything else to add, that concludes my presentation.
Basically, because it's a maintenance assessment year, we did not revalue. So just like other residential that we didn't increase upward, these executive mansions, more than likely the market decreased between the time we set the value and today. At the point that we set these values for January 1 of 2020, I believe my memory calls, there was an actual offer, not from this gentleman, but a different offer, and that's how that value was set, based off of that offer to bring it in line. But that offer fell through. And so that market segment was set with the best information we had for 2020.
In looking at the exhibit, I see on your map showing the home and the lots it's situated on. It is situated basically over 2 lots. So it's not just on one lot. Why isn't this assessed as one parcel? Lot 1 and Lot 2 assessed together?
They are assessed together.
Okay.
I noticed the objection form, or at least the one we have, only included the one parcel number. So the parcel number is 0609-051-71228 and 0609-051-7112-0. So they are assessed together. So if you look at the 2 property record cards and you add that value from both the parcel ending in 71228 and the parcel, the total assessment on the parcel ending in 71120, that comes to the total assessed value of $1,474,500.
Okay.
So they're combined. We just don't, the county doesn't combine them as one parcel, but we value them as one economic unit.
Okay, that answers my question. And you do consider this to be an arm's length transaction after reviewing, as you did through Zoom, the information with the seller? I'm assuming you talked to the seller or got some
Correct.
data from them as well as the buyer.
Yes, I asked Nick to double check all of that. It does come in as an arm's length sale. We're not disputing that. It's truly the changes that we find in the market. Even the comparables that are used in our comparable spreadsheet, it's a challenge because when you look at these comparables, their square footages are not close. So they're the best comparables we can find for this subject, but you can see the gross adjustments are significant on these. So because it's a maintenance assessment year, and we are directed not to change assessments unless there's new construction, something of that nature, we did not change this value based on market to maintain the uniformity.
Thank you.
And that would be the board's decision to do that.
Any other questions from members of the board?
And we definitely will be looking at this market segment for 2022.
Well, as I started this hearing, one of the first things I said is the Supreme Court's guidance is actual arm's length transaction of the subject property. It appears that the property owner has confirmed that, and the seller sold it for that amount, and in discussion with the buyer and seller, the assessor's office confirmed that. The fact that they're running this maintenance year when there's such a huge difference in the valuation, in my opinion, should have been reflected in the current year's actual assessment for the property. The property owner has that right to have it reflective of the change in value in a downward way, as long as it's determined to be a market transaction. So based on the evidence that's been presented and the concerns that, yes, this is going to create some inequity in that neighborhood, that will be addressed in the future. I don't think we have a choice in this particular case, but to accept the fact that all parties agree it's a market value transaction and a fair arm's length sale, and the Board of Review should look at this sale as an indicator of value and adjust the 2021 assessment to reflect the fact that the $1,225,000 sale price is a true reflection of the property's current value. So that's my motion on the floor. I'd offer it up as a motion and ask for a second.
I second.
So we have a motion and a second. All those in favor signify by saying aye.
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 All those opposed? Please let the record note it was a unanimous decision. And Madam Clerk, would you please prepare a revised assessment determination from the board for the property owner before he leaves this morning?
So for the record, he was assessed at 1,474,500, and you're adjusting it to?
1,225,000.
Thank you.
Thank you.
Thank you for coming in this morning. And thank you for your honest testimony. We appreciate it. The next thing I see on our agenda is Madison Immigration Law, 2016 Marketplace Drive, number 207. And if I understand correctly, this is a personal property appeal. Is the representative here for that? Over there, please. Wait till they're done. Thank you.
This is what you were assessed at, and this is what the board determined you should be assessed at. So I'll have you sign and date both forms. One's for you to keep and one's for you. You don't need to read the appeal information. It's 6/7/21. One's for you to keep.
Thank you for your patience.
No problem.
We never know how long things are going to go. Sometimes they go quick and sometimes they don't. So we appreciate that very much. Would you please identify yourself for the record?
Sure, my name is Attorney Huma Hassan. I'm the owner of Madison Immigration Law.
Thank you. And this is a personal property appeal. Would you, I guess this is a little different type of an appeal, but we still need both parties sworn in. So I'd ask you to stand, as well as the staff from the assessor's office, to please be sworn in this case.
Do you solemnly, sincerely, and truly declare and affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? And this you do under pains and penalties of perjury?
Yes.
I do. Amy Mercer.
I do, Nick Hare, residential appraiser.
Thank you. You might notice we're asking everybody to be sworn in each appeal this year, which is a little different than in the past, just so we make sure we have a accurate and complete record. So we beg your indulgence on that particular point. But that was emphasized in the 2021 Board of Review training.
Mm-hmm.
Not that it's a critical point, but I think it's an important point, so we're going to follow the guidance just to make sure that we do have a complete and accurate record.
Yep. And for the record, this address is 2916 Marketplace Drive, number 207, parcel 15-97141. And it's being assessed at $10,200.
Okay, and the current opinion is $500?
Current opinion is $500, correct?
Thank you. We don't get a lot of personal property appeals, but there is a personal property assessment rule located within these documents in front of us. And so it's also part of our responsibility as a Board of Review to make sure that any differences of opinion in the personal property evaluation segment of the role is also considered. So saying that, it's completely different provision, and the personal property is typically assessed by using a tax form that the assessor sends out, where you're using an indexed cost to establish an estimate of value. I guess we'll wait and see if the assessor did that, but I'd like to ask you, if you would for us, please describe briefly the property that you're concerned with and how you determined your opinion of $500 in value.
Sure, thank you. Let me just tell you a little bit about Madison Immigration Law is a solo practice law firm. We represent people of color and immigrants who are seeking to adjust their immigration status. I am the sole owner. Our legal address, I'm the owner and the agent, and our legal address is P.O. Box 9424, Madison, Wisconsin, 53725. I have a copy of our corporation from the Wisconsin Department of Financial Institutions indicating that address. What I have perceived, this is all very new to me because I've never received any sort of personal property assessment before. The office is not used on a regular basis. It's used whenever we have to meet with clients on an occasional basis. About 2 weeks ago, I was entering my office and there was an assessor card underneath the door. I almost threw it away because I thought, I don't own the building, I don't, own anything. And then I was talking to my neighbor and they said, oh, no, you should file, an appeal because maybe they've assessed you. So only until I came last week and I said, I've got this, card, I think and I found out I'm being assessed at $10,000 for a 10 by 10 office that has, a desk and 4 metal chairs and a printer. My desk and the 4 metal chairs, honestly, I started when I started the business about, I started in 2010. Ameriprise was changing their furniture, Ameriprise Financial, and I said, I'll buy your used furniture for $500, and they said, okay. So that's where I get the $500. The printer is it's a 5-year-old printer. It's about $200, 5 years ago. It's kind of on its, how printers go. It's kind of not, it's just a personal, this is a printer. So that's how I got the approximate evaluation, about $500 or $600. It's certainly nothing in the office is worth $10,000, but, and that's how I came to the assessment. And I've attached also, I think you have copies of pictures in your packet of the office. It's a 10 by 10 office. It shows you like the basic, the desk and the 4 chairs and the old printer, and, I've got a couple of black and white chairs in there.
Did you get a personal property statement from the city's assessor's office earlier in the year to complete?
No, the only thing that I received was a card underneath my door, and I was like, what is this, So this is the sort of the first time I'm being aware of any of this, is last week, Okay. And I don't know if you want the copy of my legal address for my business, which indicates it's P.O. Box 9424, Madison, Wisconsin, 53725. I received no mail at the property. My mailing address is my P.O. Box.
Okay. Well, Wisconsin law says that the property shall be assessed where it's customarily kept. Okay. So is this where it's customarily kept?
My property, yes. It's kept, it's the office.
Okay. So that means it's Fitchburg's responsibility, not Madison, even though you're incorporated, or your post office box is Madison. It's where it's customarily kept and used.
Right. But I'm just saying if there's anything legal that needs to be sent to me, it needs to be corrected in the records that my my mailing address is P.O. Box 9424, Madison, Wisconsin 53725.
Okay. When you talk with the assessor staff, did they give you a personal property return and ask you to complete it?
I didn't even talk with the assessor. I just had had a card underneath my door, and I just came and I just, filed this appeal right away because I was like, I'm going to be assessed at something, I didn't know what this whole thing was regarding until last week, So I received no notice, this is the first time that I'm here, and it is what it is.
Anything else you'd like to add?
No, that's it.
Okay. We will turn it over to the assessor who handled the personal property. And I'd just like to point out to the assessor, some of the exhibits that you refer to in different cases have been in different order in our packets. So it's been a little challenging. I'm not sure if it's that way in all of them, but at least they were in mine, that they were in a slightly different order when they were photocopied. So they're all marked and identified, and I found them, but it's just as you were going through them, I got to sort of thumb through different segments of the exhibit to find the pages. So appreciate it if you check them before you hand them out to make sure that they're in the same concurrent order as you're using. So thank you. I thank you in advance for that.
Thank you.
Who's going to testify?
I'm going to testify.
Very good. Please do.
This one, the packet that we handed out.
Did you identify yourself for the record as you're speaking, please?
Okay, I'm Amy Mercer, the city assessor.
Please continue.
Okay. So on this property, this is a new account for this year that we had. So in December, we go out and try to locate all the new businesses or the existing. We verify if businesses are here. So this created a new business. A lot of times when we have a new business, we don't know mailing addresses and that, so we will send it to the property location address. So the first page shows that we sent a letter, cover letter, and the personal property statement in December 27th of 2020 to the property location. I then sent a reminder letter March 8th for any properties that had not turned in their forms yet. So again, it went to the property location. If we have letters come back to us as undeliverable, then we'll do further searching, things like that. But I don't have anything in the file saying it didn't come back. Doesn't mean it's not at the post office or someplace like that, because I've had things come back 6-8 months later, returned to us. So then we sent the notice of personal property assessment letter on April 26, 2021, stating what that new assessment is. So the next page, this is doomaged, so personal property is considered confidential, but this is a doomaged assessment. So when
would you explain to the board what a doomage assessment means?
Correct. So when someone does not return a form, then we estimate what personal property they have with the best information we have available. So staff went out for those properties, and this one in particular, because we did not have a prior year's assessment. Typically, if we have someone reported the prior year, we can use that information again as a good estimate. In any new businesses, we need to go out and try and discover what is there. In this particular one, I believe Nick and Dwight went together to verify what was at these locations. But it was closed, and it's not like a retail that has all open windows where you automatically can walk in or see it. So there was no visual understanding of what's actually in that business, okay? So when we have something like that, we do our best because we don't have any information. And in that case, then we will take and look at other businesses that are similar, like a hair salon that might be the same similar size. In this case, the first couple pages is our estimated personal property return. So that's what a personal property return looks like. And we have an estimated amount entered in for 2020 because that's the first year the business was open, or for our records, we knew of this business there. On the page 2, we listed everything under Schedule D, which is furniture, fixtures, and equipment. And we estimated that at $11,600 at full value. Then you take that times the depreciation table for 2020, that was 0.925, and that came to 10,730. Then because it is ratioed, then the total assessment actually gets ratioed down because this is a maintenance year. But because we couldn't view anything to obtain information or talk to the property owner, there's a page here that we listed 3 other accounts and just their total assessment, and they were 3 other financial or law-type firms that had personal property accounts. So we literally took the average of the 3, and that's how we came up with the 11,600. That was the best info we could have at that. Now, the following pages are what the property owner turned in when she came in. We did not have an open book appointment or received any information, but her objection form was received on June 2nd. So that's the first we've seen these photos is then, and at that point in time, the roll has already been set, so I can't change that, so that would be up to the board to make that change. So based on her photos that she had included with her objection form, I asked Nick to go through and try and search out what the cost actually was. So he went out to a couple websites and tried to find similar items. So the following page after the pictures of what she has in the facility, in her building, we have filing cabinets where he found one price at $103, another price at $138.99. That average price is in the range of $121. Office chair, there were 4 office chairs. He found that price to be $83.34. That total came to $333.36. Desk, that ranges, so the average there was $594.84. A reception chair, there were 2 reception chairs based on the photo, the side table, and the rug. So that total of those averages, now based on the information that she's provided here to the board, that would come to 1536.45 would be an average, times that depreciation table, 0.925, came in at 1421. And then because of the ratio, it gets rounded to 100, plus it's ratioed so that it's at the same ratio as the real estate, and that would be 1,400. So following that, we just did the best that we could with finding what those costs are for each of those items, and that's what those next few pages are, just listings of that. We put that in as the 2021 or 2020 value then based off of that. So it's up to, that's all the information we had was what's on her objection form. That would be the value depreciated out if that was purchased in 2020 for 2021. If this was purchased prior for a different value of, she bought it used at $500, then we would need to put that $500 into whatever year that was purchased at, multiply it by that depreciation table to arrive at a new value.
So just so I understand, the prices you're presenting are for new furniture, not used furniture?
Correct.
Okay.
And we did that just because it was a new business. That was, the next best information we had coming into today to give the board an estimate of what we thought.
So based on what you've seen, you feel that your doomage assessment could be adjusted based on the new evidence that's been presented?
Correct. I believe the board has new evidence that they should look at. I don't have all of those pieces, so I think some of the pieces would be when was this actually purchased and if there's actual receipts, information like that.
Well, if you take the $700, the $500 for the furniture and $200 for the printer, and you put it in the year 2016, which would be 5 years on the depreciation table, it would give you a total of $358.40. So do you have any kind of receipts to show that you bought it in that time period?
I'm sorry, I don't. It was just word of mouth. They were changing their furniture, and it's like, hey.
Are you depreciating it on your income taxes?
No, I'm not. I don't even declare my furniture on my income taxes, just my net income and my expenses.
Because if you were, this would be fixed assets that could then be depreciated.
Okay.
So if you're not doing that, that's a small business, I understand.
Yeah, it's just.
Okay. Any discussion by the board? Eldon, anything you want to add?
No, nothing from me.
Okay. I think hearing the evidence that's been presented by both the taxpayer and the assessor staff and looking at the photographic evidence, I think that the board can easily reflect an adjusted value for this property using the 2016 year as original purchase year, which gives it 5 years of depreciation. Based on the testimony that was presented here this morning, that $500 for office equipment and $200 for a printer would give us then $358.40. And as we said, the assessment system's round, so this would have been rounded to $400. So for $400, I would make a motion that we adjust the personal property assessment. And I want to make sure I have the information correct from the objection form. As I look at it, Madison Immigration Law, this is an LLC.
Yes, yes, sir.
For Madison Immigration Law LLC, from the current doomage assessment of $10,200 to $400 to reflect to present a more reflective value of the used equipment that's in the office.
May I just add one more thing?
Certainly.
So if you're using 700 times 0.512 as the depreciation, that comes to 358. Take that value times 0.95, because this then gets ratioed down. So it might actually round down to $300 versus up to $400.
Okay, so what you're saying is use your level of assessment at 0.95. And what does that come up to?
300.
340, so it would actually round down to
Okay,
300.
$300.
You're doing well.
Yes, and
Please.
we have no problem, Madison Immigration has no problem paying the taxes. It's just, this is the first time
That's your
we were
problem.
aware of this. And like I said, this is the only opportunity that I had to be
I do have one quick question. Are you the sole member of the LLC?
I am. I'm the owner and the sole member and the attorney
Okay. that's
and
good
the secretary and everything.
enough. Good enough for me.
Okay, so the motion has been amended to be $300, not $400. I would open it up for a second.
I'll second.
Motion and a second. All those in favor signify by saying aye.
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 Opposed? Opposed, hearing none. Let the record note the personal property assessment for Madison Immigration Law LLC has been revised from $10,200 to $300 as indicated as if they had filed their personal property return and appropriately adjusted based on the depreciation tables.
Great.
And we will update the mailing address
Yes,
to your
please.
PO
These-
box, and so in the future,
I'll get
everything
the
will
the
go-
notices. Yeah, please do that, because our legal address is the PO Box 9424, Madison, Wisconsin 53725. And like I said, I would be happy to pay whatever taxes. It's just, this was all kind of a bit of a surprise.
I don't think it's going to break the bank. It'd probably be under $10, so.
Oh, okay, fine. Like I said, we're happy to pay the taxes to support the community. It's just, I didn't know, until I got the card. Thank you very much for hearing this.
Thank you for being patient and waiting for us. as the clerk is assisting the taxpayer with the paperwork, starting with that appeal. Looking back at our agenda, we have completed all the hearings that were scheduled for today, but that does not complete our work. And that, I still have to sign those subpoenas, I guess.
And Amy had asked me to ask before the board adjourns today, if when you take a break, to see if you would, if you were planning to talk with the city attorney about the next steps, the procedural steps dealing with Bowman Farms land parcels.
The answer is yes, we are. So the next thing would be item 15 on our agenda, which is scheduling the next session of our board of review. We need to give the assessor some time after those subpoenas have been mailed to have an opportunity to review the data and information to make sure that they can properly reflect any impact it has on the values they've created. And in getting a heads up from the clerk yesterday, I looked at my calendar, and I'm hoping that the date of July 22nd would be an option that would work for most of us. I know there's one person here who's smiling because he won't be here on July 22nd, and that's Craig, which I'm very sad to say. He's leaving Fitchburg and moving to the village of Oregon. And I want the record to note we've been very pleased with his support and help and guidance in the appeals that we've had in the last couple of years. And his background and knowledge has been very helpful.
Well, thank you. It's been an honor to serve with all of you.
We certainly can't fault him for moving to that hopefully forever home that he's found, the village of Oregon. So thank you very much for your service.
Thank you. One quick question. I saw there's 14A and 14B. Did we cover those? And I have a Post-it note on my packet that says review. And I didn't know if we took those up yet or not.
We have not.
Or is that just part of this?
Nope, those are 3 commercial properties, or actually multiple ones, but 2 are hotels that have, the first 2 are the 2 hotels that we've received the majority of information and we've prepared for. Our attorney Seibel has not seen those yet, so I'm not sure if she may think that we should receive some, ask the board to do subpoenas on those at all. And then the Fred Fitchburg retail, those parcel numbers, and there's actually one that's not listed on here. So that would be 0609-031-5517-2, and then 0301-5526-8. And, that one is not assessed with the 0317180-2, so those would be separate. One is a residential property, and the other 2 are 2 vacant land parcels. But again, those are ones that I don't believe the form was filled out completely. So I don't, that's one that I think you should really look at if those forms are filled out accurately and completely on.
So what I'm hearing is that the hotels, that are motels, whatever they are, they're appealing. You feel that their forms are not complete, their objection forms?
No, I believe those 2, let me just pull those out quick. Let me double check those again. There's a lot that came in at different times, so. Actually, let me look at these. This will be better. Find the 2 in here and see if I have notes on them as to anything that's missing on them.
Well, I have the objection form for LAXMI, LAXMI, LLC, Nesbitt Road. And it says there was a 2015 sale, but there's no indication of value.
Let me find. One is the Staybridge and one is the Country Inn and Suites. Both property owners had met with us during open book and had discussions and provided information. So we actually did prepare them for today. I apologize, there's a lot for me to look through here for.
Well, I looked at them, and since they're in the packet of all the materials, they are trying to use discounted cash flow analysis to project a value for the 2020 assessment year based on the COVID situation where they had a substantial decrease in occupancy. I guess I'm not sure what your recommendation is then on these parcels. Just to review the objection form to make sure that they're acceptable before we schedule a hearing?
All right, so.
Sorry.
Nothing's highlighted here. So I think the Ravine Shaw, I believe that one, we have everything, and that one I think is good. I don't notice anything on that one. And Gary Kohlenberg, where's his here?
Well, while you're looking, I'd ask the members of the board, how does the July 22nd date fit your calendars?
It's good for me.
It's a
Yeah.
Thursday.
Actually, I'm also moving to Oregon sometime in late July. We haven't nailed down a moving date yet. And so I think the current owners have to be out by the 19th, but we haven't nailed down when we'll be moving. So I can't really say. 22nd might work.
I'm staying. I got family in Oregon.
And I can check with Erica too, so.
Okay.
How about you, Elton? How does the 22nd of July work? It's a Thursday.
Can't hear you, Eldon.
Yep, I just realized I'm still muted. I think the 22nd works fine.
Okay.
Where's the seafood place? Where's the?
Please check your calendar, and if there's conflicts, please get in touch with the clerk as soon as possible so we can make sure we have a quorum.
I used to go there all the time. I grew up in Maryland.
Okay.
It doesn't happen this time of year.
Yeah.
Alternates.
And the only thing on the J-Ma Laxmi LLC property, they didn't fill in their purchase price. They did list the sale, but didn't fill in the purchase price.
Okay.
So I have no issues with those two properties, basically. But the Fred Fitchburg retail, those parcels are the ones that he actually withdrew last year, and I don't believe he filled those forms in completely this year.
Okay.
So we may want to issue subpoenas to require that info.
Well, since we're not adjourning, I will discuss these with the city attorney. And based on her guidance, we will either deny the appeals because the form's not fully completed, or we'll provide you with accurate information so that you can request the data that you feel is important.
Okay, so I think all we need to do is have a motion to act on the scheduling of the second date and time and a second.
I think we're acting in slow motion.
Feels like it.
All right, at this point, we're not sure if we have a quorum or not, but we've picked the date of the 22nd of July, 9 o'clock in the morning as the next date for our Board of Review to continue. And as we work to put that date in place, the clerk will make sure that we have a quorum by reaching out to either additional members of the board or alternates so that we can continue our 2021 appeals. That being said, I would open the door for a motion to, I can't say adjourn.
Yeah,
but I'd
we
like
adjourn to the next meeting. Yeah,
Adjourn to the next meeting?
well, we adjourn.
Adjourn to our next meeting date? Is that appropriate language? Okay. We'll adjourn to our next meeting, scheduled for July 22nd, at 9 o'clock in the morning. That's the year 2021. All those in favor, please signify by saying aye.
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 All those opposed, better keep quiet. Well, Matt, I'm also sorry to hear your news. I'm happy for you, but sad for the board. So at this point, I will draw this meeting to a closure at 12:48.